is really trying to get back on track. She wants to do mental health services. She wants to get back to college.
Ms. Woods, anything you want to tell me?
I want to apologize, but I lost my kid. I lost my whole life, and I have messed up over and over again. But I've been in my cell by myself for over a month now, and I've been a lot of thinking. I finally have grieved, I guess. I just get more jail time. I just want my life back. I miss my son. I'm sorry. I just want my life back, and I will take it back, whether you give me more time or you don't, because I'm done with this life. I'm going to make my son proud of me and her up there. And I'm sorry that I came into your town and made a mess of it.
All right, court has considered the statements made here today, the purposes and the principles of sentencing, relevance, seriousness, and recidivism factors. Ms. Woods, the court recognizes that you have issues in other states that you have to comply with. I know you're not from around here. You're from Indiana, correct?
Yeah, I live in Ohio.
Live in Indiana, yeah.
But yeah.
You're not currently, plan on staying in Ohio. All right, at this point in time, what the court's going to do is I'm going to order you to serve 120 days in the Warren County Jail. I'm going to give you credit for the 120 days you've already served.
You are?
Yeah, I'm done. Yeah, but you're not getting released today because Kentucky.
No, I don't care. I get a chance. You gave me a chance. Thank you. Thank you so much, Your Honor. Thank you.
All right, now let me finish this because there's some other things I have to tell you. You're subject to a discretionary period of post-release control, which means that if you are sent to prison on discharge, which I'm not sending you to prison, but if you were sent to prison, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost, including an attorney. Ms. Nicholson.
You just want that a straight 120 days, no community control in term, just straight.
Yeah, she's going to Kentucky now.
Okay.
So,
Sounds good.
We know what Kentucky is.
Yeah. All right. Good luck to you, man.
Thank you so much, sir.
Thank you, Anna.
And she's indigent, obviously.
Yep.
Okay.
Thank you.
tell you to do for a period of up to 60 days. That's mostly so that we can ensure a smooth transition to the community. I don't really want to limit your movements, but I want to know where you are. But if Officer Martinez thinks that we need to go to a curfew or something like that, I'm going to delegate to her the authority to do that. I'm not going to impose a fine. I am going to impose the costs upon you and give you the credit for the 51 days that you have already done. If you violate the terms of your supervision or you leave the state without permission, I can send you to up to the maximum penalty in this case, which is 12 months in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, it will all be provided to you at no charge. Anything else?
Just one question, Your Honor. What is the term of the probation?
3 years.
Thank you.
Nothing further, Your Honor.
All right. Good luck to you, Mr. Sonny Cab.
All right.
So we have another ILC hearing to do. Mr. Ocello, do you want to talk to Mr. Stover for a little bit before we get going? What's your preference on
That
that?
would certainly be of assistance if you don't mind.
Okay. And do you have a copy of the letter from Dr. Adkins?
A digital copy. I don't have an actual hard copy. Do you have one that I can?
I can get the bailiff will probably be willing to provide you with one.
Thank you. I appreciate it.
So we'll
I can
have
go
it
ahead.
printed out.
You want me to print it out right there?
Oh, that would be. Over, come back up here. So, Mr. Stover, you want to be represented by a lawyer in these proceedings, right?
I thought that's what Mr. Chicarelli was.
Cello.
Ocello.
Sorry, Cello.
Okay, I just got to check these boxes that I haven't checked yet. You want to be represented by a lawyer, right?
Yes.
And do you have the money to hire a lawyer?
I do, Your Honor. Can I just represent myself, Your Honor?
That would be terrible. You can, but that would be terrible.
I promise you, I was just sick. I made up one of my days. And I was going to make up the other day that I missed the day before. I talked to my counselor as soon as I missed days. I was sick on Thanksgiving. It sucked.
Why don't we do this, Mr. Stover? I'm going to appoint Mr. Cello to represent you right now,
Yeah.
so you can talk to him about this.
Thank you.
I think that he probably needs to have a little discussion with you about how deep the water is for you today, Mr. Stover.
Yeah.
Because if we go forward with a hearing and I find that you have violated the terms of your conditional release, don't speak, Mr. Stover.
Yes, Your Honor.
If we go forward with a hearing today, and if I find that you have violated the terms of your conditional release, I'm sending you back to Summit. This is not you're going to do some time in the jail on a contempt. If I find that you have done any of the things that they say that you have done, then I'm going to send you back to Summit. So talk to Mr. Ocello and see what it is you want to do today.
Doesn't that mean that I go to Summit then?
That does mean that you go to Summit.
I just gas it up and send me to Summit. I apologize. I was sick on Thanksgiving. I missed 2 classes. I talked to my counselor. She said that I can make
Talk to
them
Mr. Ocello, Mr. Stover, and then decide what you want to do. And then let me know what you want to do. All right, let's take a quick break and I think, Mr. You printed Dr.
Thank you.
That's a good thing.
Sí, eso es muy bueno.
Apparently, there was a traffic crash that resulted in this ticket.
Aparentemente hubo un choque de tráfico y por eso le dieron esta multa.
Mr. George, the no operators instructional permit violation is under ordinance.
El señor George, que es el que se encarga de las violaciones de tráfico, dice que hay una ordenanza en esto.
Her driving record shows that as of now, she has a fully valid license.
Su récord de manejo muestra que usted tiene una licencia completa en este momento.
We were doing allowing on that charge.
I'm sorry, I didn't hear that.
I'll repeat it. The gentleman in the back row there is Mr. Timothy George. He's the city attorney for Sturgis.
El señor de azul es el señor Timothy George, es el fiscal de Sturgis.
That charge of violation of your instructional permit
Esa violación de su permiso para manejar
could cause your driver's license to get suspended.
le podría costar que le suspendan su licencia de manejo.
So they would dismiss that charge
Pero ellos van a retirar ese cargo
and reduce it to a charge of allowing another to violate the motor vehicle code.
Entonces le están rebajando la ofensa y están diciendo que le van a poner el cargo de que usted permitió a otra persona manejar su vehículo, que es usted misma.
That is a misdemeanor,
Ese es un delito menor.
but it doesn't carry any points.
No le van a poner puntos en su licencia de manejo
It doesn't go on your driving record.
y tampoco lo van a registrar en su récord de manejo.
And it won't affect your ability to keep or maintain your license.
Y tampoco le va a afectar para mantener su licencia de manejo.
Do you have insurance now?
¿Tiene usted un seguro de automóvil en este momento?
No, ya no tengo el auto.
No, I don't have the car anymore.
The prosecutor may be unlikely to reduce this charge
El fiscal le está reduciendo el cargo
in light of the fact that you were in a traffic accident
porque se involucró usted en un accidente de tráfico
and you don't have valid insurance now.
y no tiene usted un seguro de automóvil válido en este momento.
If you plead guilty to the no insurance charge,
Si se declara culpable al cargo de no tener un permiso un seguro de automóvil,
I'm going to fine you $200
le voy a dar una multa de $200
plus the state minimum cost of $125.
más otra multa del estado, $125 mínimo de multa.
And if you plead to the other reduced charge, that will cost an additional $100.
Y si se declara culpable del otro cargo adicional, son otros $100 de multa.
And I will give you time to pay it.
Le voy a dar tiempo para que pague todo este dinero.
If you wish to plead not guilty,
Si usted
we
quiere
can set
declararse no culpable,
it for further proceedings.
podemos programar otra audiencia.
As to the charge of driving on November 14th without valid Michigan insurance, how do you plead to that charge?
¿Cómo se declara al cargo de haber manejado sin un seguro de automóvil el 14 de noviembre? ¿Culpable o no culpable?
Culpable.
Guilty.
As to the charge of allowing another to violate the motor vehicle code for the restricted license, how do you plead to that charge?
¿Cómo se declara al cargo que le están haciendo de violar, de darle permiso a otra persona a manejar que es usted misma?
Culpable.
Guilty.
Did anyone threaten you to get you to plead to this?
¿Alguien la amenazó para que se declara culpable de este cargo?
No,
No.
Or promise you anything?
¿Alguien le prometió algo?
no.
No.
Fine for that is $100 for the license charge.
Le voy a dar una multa de $100 por el cargo de la licencia.
This is a lot of money. It's going to be $425 total.
Es mucho dinero. En total son $425.
Can you pay that today or do you need time to pay it?
¿Necesita usted tiempo para pagar este dinero o puede pagar hoy?
Sí, necesito tiempo.
I need some time to pay the money.
We'll make that due by January 9th.
Le está dando hasta el 9 de enero para pagar todo el dinero, señor.
Ok, perfecto.
That day that you were in the accident, did you not have any insurance on your car?
El día que tuvo usted el accidente, ¿no tenía usted seguro de automóvil?
No.
No.
She needs to get fingerprinted for this.
La van a mandar a que le saquen huellas, le tomen sus huellas digitales, dice el juez.
$200 fine.
$200 de multa.
And $125 of cost.
Y $125 de costos.
The total that you owe is $425.
En total, usted debe $425.
What do you do? Do you work somewhere?
¿A qué se dedica? ¿Trabaja usted en algún lado?
Sí, trabajo en la empresa de Clemens en Coldwater.
Yes, I work in Clemens and Coldwater.
At where?
Clemens.
Clemens, okay. That is really hard work.
Ese es un trabajo muy duro,
Sí.
It pays well.
pero paga bien.
You get lots of overtime.
¿Le dan mucho tiempo extra de trabajo?
No, algunas veces. Ahorita la temporada ha estado poco suave.
No, not right now. The season is slow right now.
You owe $425.
Debe $425.
It's due by January 9th.
Tiene que pagar.
Her advice of rights is up there somewhere.
Tiene que pagar el 9 de enero, dice el juez.
Okay.
If you need more time, contact the court.
Si necesita más tiempo para pagar este dinero, contacte de inmediato al tribunal.
Okay.
Okay.
You acknowledged on your advice of rights that you were giving up your right to have a trial in this regard, and we'll attach that to the file.
I do. I'll put you in a breakout room. Okay, thank you.
Yeah.
All right, 30 court now session on Montgomery County.
All right, be seated, please. I really do apologize. We just had something come up this morning and there's just Corrigan Oil, 25S118269, Corrigan Oil. Somebody here for
They're on
Corrigan
Zoom.
Oil? They are?
Yeah, they're coming in right now. It's a little slow.
Oh, okay. Good morning, Mr. Mange, your appearance.
Bradford Mays appearing on behalf of Corrigan Oil Company, Your Honor.
All right, so you met with the prosecutor. He's offered a plea to overweight with agreed upon fines and costs of $900, true?
That is my understanding, Your Honor. That's correct.
And you're authorized to enter this plea on behalf of the company?
I am, Your Honor.
To the charge of overweight violation, responsible or not responsible?
Responsible, Your Honor.
All right, I'll accept the plea. Fines, costs of $900, paid by January 9th of 26. Have a nice Christmas. Thank you.
Thank you. You do the same, Your Honor.
Lorenzo Lee Whitfield, 25 M61977 A and B. Come on up to the podium, sir. Ms. Tucker Davis, what are you here on?
Your Honor, I have 4 cases this morning. They will be waived and bound over except for the Brown Williams case. We were asked to come in early. They are accepted into diversion.
Then were the exams drawn?
Yes. Jessica Payne is a waiver and
Okay, hang
Janelle
on one
Bruce-
second. Hang on one second. The exams this afternoon.
10 o'clock and 2:30.
You're going to waive all those?
Yes, Your Honor, except that Tiffany Brown and Christian Williams are accepted into diversion program. Jessica Payne, Bruce, and I have not spoken to Mr. Arslan yet.
Yeah,
I
I'm
was
still
just,
not understanding what you're saying. The 2:30, is it waiving?
The 2:30 is accepted into diversion, Your Honor.
Well,
And then they're waived and be
Yeah,
accepted into
okay.
diversion.
okay, give me 1 second here. I'll gather the files. What in the world's going on with me? There we go. All right, your name, sir?
Lorenzo.
Can you get those? Try to get those. Mr. Whitfield, you're charged with no license and you're charged with speeding. And you have the right to a lawyer if you want one. Do you want a lawyer?
No.
I'll arraign you and then I'll send you to the prosecutor, okay?
Okay.
On November 4 of 25 at 4 p.m., it is alleged that you did operate a motor vehicle on I-75 northbound near Gibraltar Road in Brownstown without a license. That is a misdemeanor, punishable by up to 500 fines, 93 days jail. Costs are all those. You also have a speeding citation, 93 and a 70, which would be a, let's see, that is going to be a 4-point not 3-point violation, I think. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea. I'm going to give you a personal bond, $500. You don't have to post any money. I'm going to enter a plea of not guilty on the misdemeanor, plea of denial on the speeding. And you can go out in the hall and he is going to take this file to the prosecutor and we'll talk to them. Okay?
All right, thank you.
Thank you.
Yeah, the prosecutor's here to clear all that up.
Yeah, so I just need the file. She's saying she's going to waive the 10:30 and they're going to accept them in the diversion.
Those ones were set for 2:30 PM. I handed both the files. There should
Same
be
step funds.
Tiffany Brown and Christian Williams.
Is your client here on that?
Yes, Your Honor. Ms. Brown should be on Zoom.
And is Ms. Brown on Zoom?
Yes.
Okay, let's bring her in. Good enough. Tiffany Monet Brown, counsel, I'm going to be right with you. I'm not. Okay, just give me a second. I want to spend some time on that. I didn't like what I read. 25M7168822. All right, ma'am, your name?
Tiffany Brown.
Ms. Tucker?
May it please this honorable court, Don Tucker Davis representing Ms. Tiffany Brown. My bar number is P59229. Ms. Brown is present on Zoom with her permission, Your Honor.
Ma'am, and you're telling me she wishes to waive her right to an exam, correct?
That is correct and will be bound over. And at that point, she has been accepted into diversion.
All right, is that what you want to do, ma'am?
Correct.
All right, so you're charged with false pretenses, 1,000 or more, but less than 20,000. That's a 5-year felony. You have the right to an exam. If you waive your right to an exam, you're waiving the requirement that the people show that the crime was committed and that you were the one who probably committed the crime, and you'll be sent to the criminal justice center for further proceedings, and we're not going to have a preliminary exam. And again, you're waiving the requirement that they prove probable cause to believe that crime was committed and that you were the one who probably committed the crime. Do you understand that?
Correct.
You still wish to waive your right to an exam?
Yes.
Anybody force you to do that?
No, sir.
I'll accept the waiver. Ma'am, you are bound over for further proceedings to the Wayne County Circuit Court. The AOI date will be on December the 23rd. December the 23rd, okay?
Okay. If I cannot make it that day,
Do, Mr. Stover?
No, Your Honor, please send me to Summit. It's a better facility for me. It's better than county. It does way more.
Yeah, I think what Mr. Ocello is proposing for in the short term is a better plan. So let's set it next week. And if you decide that you don't want to contest these allegations and you want to go to Summit at that time, at least Mr. Ocello will have had time to review the allegations against you and talk to you a little bit about that.
They're all true. They're all true. I can't deny it. I messed up. I've not contacted them because I was sleeping. I missed a couple appointments that I tried to make up. I did test positive for THC and Adderall. I admit to everything that they said on there. I couldn't say anything. I'm just doing my best to stay safe and stay sober. And I am sober, so I'm happy. But apparently it's not enough. It's I apologize. I really am doing my best. I really am. I was like so excited to be out for Christmas this year. I apologize. All this little petty bullshit that you have to deal with, them contacting you because I'm not answering or missed appointments. I'm sorry. It's my fault. It's my fault. I don't know if I have memory issues or what. It makes it hard to follow a straight schedule. I really am sorry. And I don't have any means to stand on any of the allegations they have against me. All the allegations are right.
All right, I'm going to set this for a status conference next week. Mr. Ocello, get with Ms. Idle and get that set. Talk to Mr. Stover. You have a copy of the report, and Officer Bittinger received a report from the treatment folks about his compliance or non-compliance, and we'll see where we're at next week.
Yes, I have copies of both. Thank you.
All right, that's all. Case of the state of Ohio versus, is it Nayla? How do you pronounce your first name, ma'am?
Nayla.
Nayla Patterson, case number 25 CR 42767. Present before the court is Ms. Patterson, represented by Mr. Madden, and we have Mr. V from the prosecutor's office, Officer Rose from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, sir.
We have 3 days of jail time credit and no restitution. Does that sound right to everybody?
I think there's $35 on for the drug testing.
$35 in reimbursements. All right, any reason not to go forward with sentence today?
No, Your Honor.
Mr. View?
Nothing additional from the state, Your Honor. Thank you.
Officer Rose?
Nothing further, Your Honor.
Mr. Madden?
The only thing I'd like to bring up here that I didn't mention, Becky Chambers, is I believe she resides in Franklin County. And I wonder if she's wondering if probation can be transferred up there. We talked about, she's going to talk to me about that.
All right, Ms. Patterson, anything you want to tell me? So here's the thing, Ms. Patterson, I have 2 prisons in my jurisdiction, and I see a lot of these. And I see a lot of people bringing drugs into the jail. And what I used to do when I first started is I used to put everybody who brought drugs into the prison, I used to put them in jail for 90 days. I don't do that anymore because what I learned over the course of the early part of my career is that's way too much for 90% of the people who are involved in these kinds of things. People who bring drugs into the prisons, they have no idea the threat that they bring to the prison. They have no idea what happens to those drugs when they get into the prison, the fights that result, all of the problems that come along. And I think that you probably fall into that category, that this was something dumb, you have no priors, and that you'll probably never do anything like this again. So that's the way I'm going to go. There's a small percentage of my cases though with people that are like, this is what I'm going to do regardless of what you say. And my hope is that you are not among those people, but those people also end up serving time in jail, going to prison. So I am going to put you into my community control program, 3 years of basic probation. It does make sense to transfer this supervision to the county where she lives. I'm not going to impose a fine. I am going to impose the costs, order that you complete 40 hours of community service on or before April 1st. So you have until April 1st to get those 40 hours of community service done. I'm not going to impose a fine. We have $35 in reimbursement, and we have 3 days of jail time credit. If you violate the terms of your supervision or you leave the state without permission, I can send you to up to the maximum penalty in this case, which is 36 months in prison. It is also a special term of your probation that you are not to be on the grounds of a detention facility, a jail, a community-based corrections facility, any place where they house inmates. You are not allowed to be at that facility unless you are one of the inmates. Can't visit anybody at a jail or at a prison during the time that you're on community control. Anything else? Anything I forgot?
Did you want any no contact orders, Your Honor?
So the person that she needs to have contact with, that they share a child, is in the prison, right? What's the contact? What's the relationship to the other co-defendant?
I don't know them.
Okay, so no reason not to put down a no contact order. I'm not going to put down a separate no contact order as to the father of her child, because I think that's a little onerous, but she's still not allowed to visit him in prison.
That's
She can-
Mr. Lyons, right? The father of the child's Mr. Lyons.
So you can correspond with him if you want. You can write him, whatever they do on their tablets these days, but you're not allowed to go visit him. Okay? And that's not him specifically. That's encompassed in the other order, which says that she's not allowed to visit anybody for any reason. All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. Good luck to you, Ms. Patterson.
Thank you.
Let's go back on services.
All right, clear and recess. Slowly clawing our way back to being on time.
Need the file. She's saying she's going to waive the 10:30 and they're going to accept them in the diversion.
Those ones were set for 2:30 p.m. I handed both the files. There should
Same
be
step ones.
Tiffany Brown and Christian Williams.
Is your client?
Oh, thank you. We'll talk about that, Ms. Brown.
Oh, okay.
Thank you, Your
I
Honor.
can't do anything to change the date, ma'am. I'm
Okay.
sorry.
Okay.
I wish you well. Good luck. Thank you.
Okay, thank you.
Do you have
You're all
Christian
set, Ms.
Williams too? Ms. Tucker Davis, do you have Christian Williams too?
I do not represent the co-defendant. Ms. Patillo does.
Is Ms. Patillo going to log in? Do you know?
Judge McNally.
Yeah.
Priscilla did message me. She's doing a few cases in circuit court. She's gonna log this.
Is Mr. Williams going to be here though?
She stayed. And I'm here over Zoom.
Perfect. Okay, I'll wait for that. Thank you. Thank you. Do you have anything else, Ms. Tucker Davis, with me?
Judge,
I
if you
do.
have Payne, she's in custody.
Payne?
And that's Miss Tucker Williams also.
Do you have Payne?
I do have Miss Jessica Payne, and I also have Janelle Bruce, Your Honor. and
Okay, let's
Ferris
take
Arson.
Jessica Payne, Jessica Lynn Payne, 5B 728-622.
May it please this honorable court, John Tucker Davis representing Miss Jessica Payne. My bar number is 59229, Your Honor.
Morning, Ms. Payne. Your name?
Jessica Payne.
Good morning to you, ma'am. So this is the, let's see what I have here.
That's not, okay, all right, go ahead and see.
Ready?
where we're at on all of this, Mr. Johnson. Two things that you need to know about me is I worry a lot and I'm a very jaded person by nature. So I received some reports that you violated the terms of the Halloween conditions for our sex offender program.
Yes, sir.
That you didn't do what you were supposed to do, that you weren't in compliance with that. I worry about that, especially with people who have been charged with the kind of things that you have been charged with.
Yes, sir.
So I'm very concerned about that. I worry about it. And I'm very jaded to think that your excuses were not sufficient. We've had the chance to explore this a little bit further, and Officer Henry tells me that he doesn't think that you are in violation of any of the rules of your community control. He thinks that this series of, I don't know if we're going to call it bad luck, coincidence, whatever, that led to you being out working on your car during the Halloween thing, it's not really a violation of your probation. So the proposal here today is to dismiss this violation and get you back to where you were when we started. I assume that's okay with you.
Yes, Your Honor.
Mr. Harris?
Nothing further, Your Honor.
Probably ought to make a good record, Miss Officer Henry. What happened in all of this?
Your Honor, so this is in regarding to October 31st of this year regarding the Halloween class. So for any of our clients that are presently on supervision under a sex offense or qualifying offense, they are required to attend a mandatory meeting here at the courthouse during the times that are observed for trick-or-treating. On the date of Halloween, Mr. Johnson had reached out to me with documentation from Kettering Health that he had received on, was into me showing a rash that had spread onto his face and neck region. I had given him approval to stay home during the times of the period that was observed for trick-or-treating, but explained that we would have field teams that would still go out to the house to address and make sure he was in compliance. Per the report from the field officers that made contact with Mr. Johnson, they arrived just shortly after 8 p.m. and they had found him out in the driveway working on his roommate's car. But at the time, technically it was after the trick-or-treating hours observed, and there were no trick-or-treaters in present sight. Outside of him working in the driveway, there were no decorations that would have been visible outside of a pumpkin that was seen in the back of his garage. Mr. Johnson had claimed to me that during the times that there was trick-or-treating, all the lights were off and that there were no decorations present. It is my opinion at this current time, given the current health facts regarding the shingles virus, that he still would have been approved to not report into the courthouse given an infectious window following the shingles virus. And is the main factor in regarding why I'm requesting a dismissal of this violation.
So more importantly, Mr. Johnson is sober and in compliance with all of the rules of probation otherwise, right?
Yes, Your Honor. Outside of this violation that was filed, I would consider Mr. Johnson to be in complete compliance with his supervision. We are additionally working on his current court costs, and I would imagine that if the violation is dismissed today, we'd be working towards either a request for termination of his community control or he'd serve out the remaining time, which is April of this coming year.
Anything you want to tell me, Mr. Johnson?
I apologized, and I just didn't want to come in and give shingles to people, and I went outside and was getting tools on my roommate's car as he asked me before he went out, and right at that moment, that's when the two ladies pulled in. Oh, I didn't mean no disrespect, and I'm sorry.
I don't know that you have anything to be sorry about, Mr. Johnson, because it seems like that this is just a sort of a combination of factors that did not rise to the level of you violating your supervision. The more important thing to me is that you are remaining sober and committed to being sober, because the last note that I have about this case was back in October of 2023, where You and I, Officer Pierce, had a discussion about how you appeared to have no interest in remaining sober. That seems to have changed, and
Extremely.
I'm glad about that.
Extremely.
Really am. All right, I'm going to dismiss the violation.
Thank you.
Have a good Christmas.
Merry Christmas.
Mr. Johnson, just wait for me a moment. I don't know if we've ever checked that box before, Mr. Harris.
All right, so we have, this is the date scheduled for exam, I believe. And as I understand it, this will be a waiver. Is that true, Ms. Tucker Davis?
It is, Your Honor.
All right, ma'am. Your lawyer tells me you wish to waive your right to an exam. Is that true?
That is.
You have a flee and elude third, which is a 5-year felony. You have a possession of less than 25 grams of cocaine, a 4-year. You have assault, resisting, obstructing officer, a 2-year. And then you have a misdemeanor charge of operating a motor vehicle while suspended. You have the right to an exam on the first 3 counts. If you waive your right to a preliminary exam, you're waiving the requirement as to those counts that they prove that the crime was committed and that you were the one who probably committed the crime. And you'll be bound over for further proceedings to the circuit court. Do you understand that?
I do.
Has anybody forced you to give up your right to an exam?
No, they have not.
And you understand by doing so, you're waiving the requirement that they prove, again, that these crimes were committed and you were the one who probably committed the crimes and you're going to the circuit court for further proceedings. Do you understand that?
I do.
All right, I'm going to go ahead and accept the waiver. I find the waiver has been made voluntarily and understandingly. You're bound over for further proceedings to the Wayne County Circuit Court. You will be there on the 16th of December at 9 a.m. And is there anything else on this case, Ms. Tucker Davis?
No, Your Honor, there's no bond argument.
Bond is continued. December 16th, 9. I wish you well, ma'am. Same bond conditions, okay?
Okay, thank you.
Good luck. Thank you. So I'll put POs aside. And you have Janelle Bruce too?
I do.
People against Janelle Bruce. Janelle Bruce, 25R7244410.
May it please this honorable court, Don Tucker Davis representing Miss Janelle Bruce. Miss Bruce is present on Zoom with her permission, Your Honor.
Okay, thank you. I don't see her. Is she?
I moved her, but she's stuck out there.
Okay.
It's moving slow today.
Oh.
It's okay.
Yeah. Gary,
Okay, no, she logged in on a new device. Let me see if I can get her in on that.
Okay. All right, Ms. Bruce, you have to unmute and tell me your name, ma'am.
Sorry, sir. My name is Janelle Bruce.
Okay, Ms. Bruce. And Ms. Tucker Davis, your name again for the record.
Dawn Tucker Davis, P59229, representing Janelle Bruce, who is present on Zoom with her permission.
And this is going to be a waiver, true?
That is true.
Ma'am, is that what you want to do, is waive your right to a preliminary examination?
That's correct, Your Honor.
You have a 5-year felony, flee and elude 3rd degree, and an assault, resist and obstruct, a 2-year. You have the right to an exam. By waiving your right to an exam, you're waiving the requirement that they prove that the crimes were committed and that you were the one who probably committed the crimes, and you will be bound over for further proceedings to the circuit court. Do you understand that?
I understand.
Do you agree to that?
I agree.
Anybody forced you to give up your right to a preliminary exam?
No, Your Honor.
And you still wish to do that?
I do.
Waivers accepted. I'm going to go ahead and continue the bond, 10,000 PR. You're bound over for further proceedings to the Criminal Justice Center since you're not in custody. December 23rd at 9 a.m. will be the AOI date, okay? So I'm going to bind you over for further proceedings on those counts. Do you have any questions, ma'am?
No, Your Honor, I don't. Thank you.
All right, I wish you well. Good luck.
Thanks.
Ferris Arslan. Oh, you guys are killing it.
Your Honor, Dawn Tucker Davis, I'm representing Ms. Ferris Arslan. Is Mr. Arslan present on Zoom?
He's not on Zoom, but he's not set till 9:45.
Okay.
He was in person at the last hearing.
If you want to check back in about a half an hour, that'd be fine, okay?
Thank you very much. I'll log out and come back.
Thank you. Thank you. Rodney Sean Tuttle, 25B701-845. Again, counsel, I can't apologize enough. I'm sorry.
Quite all right. I was running late myself.
Okay. Well, I wasn't running late, but things are always happening around here. Your name?
John Freeman, I'm
Mr. Tuttle, your name?
Sean Tuttle.
Your client pled to attempt R&O, and use of meth. So we've got 3 counts. Have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
Your Honor, I should note that he is currently employed with his father in the state of Kentucky doing construction, but he's an under the table kind of job, but he is working. I can appreciate that the court might want some verification of that moving forward, and I've explained that to him. There is, it says here that he's not employed, but he is in fact working.
All right. Okay, I'll modify the report in that aspect.
Your Honor, other than that, there are no additions, corrections, or deletions that are necessary.
All right. Anything you'd like to say? And I'm going to just tell you, I don't go for this guy hitting people and hitting police officers. So he might not be walking out the back exit way today. Okay.
Well, Your Honor, I'd ask that you reconsider that. I've watched the video in this matter. He was given a lawful order by the police. He did run from the police. The police did have to tackle him to the ground.
The officer says here, as I reached out to grab Tuttle's wrist, he pulled away from me. I reached again for his arm. Tuttle punched me on the right side of my forehead. I lost my balance and fell down to the ground, and Tuttle took off running northbound on Kirby. Are you saying that the video doesn't show that he got punched in the forehead?
I did not see that in the video. I saw.
Where's your office at?
In Newfield Hills. My view of the video is that it was basically a struggle while my client was on the ground refusing to be handcuffed. And I know that Mr. Muhammad had direct communication with the officers involved in the case before.
Hang on 1 second.
Yes.
Hey, this is Judge McNally at 33rd. Can you, I need to know if Officer McParland from Brownstown is on duty today. Perfect. I'd like him to appear on Zoom for me right now, okay? I'd like him to, I've got this Rodney Tuttle case and I'd like him to Zoom in. Okay? Thank you very much. Why don't you have a seat 1 second? As soon as he zooms in, I'll recall it, okay?
Your Honor, I do have the video on my laptop. Wants to watch it.
Okay, I might take you up on that. Okay, thank you. If he tells me what's in the report is accurate and you think it's not, I'll be glad to look at that video, but you don't punch police officers in the forehead or in the face or anywhere else. So, all right, well, we'll find out. Timothy Allen Gallagher, 25M624-205A. Which one do you have, Mr. Zelnick, and which one do you have, Mr. Graziani?
I've got Catherine Bustler touch. And I have Miss Norton, Your Honor, G-H-O-R-G-O-S.
Okay, give me just
D-O-Rs.
Give me just 1 second. Your name, sir.
Timothy Allen.
You're charged with no license and speeding and illegal window tint. So you got an A, B, and C file. You have the right to a lawyer. Sir, you have to take your hat off. If you want a lawyer, I'm going to give you one. If you don't, I will arraign you and let you go talk to the prosecutor.
I didn't have to, my mom was baptized when it was the fraud.
No. I'm just asking, do you want a lawyer to
No, I'm sorry, no.
Okay, I'll go ahead and arraign you, and then we'll send you to the prosecutor. On November 18 of 25, it is alleged that you did operate a motor vehicle without a license, a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those. You're also charged with speeding 16 to 20 over, which should be a 3-point violation, and illegal window tint. You have a 0-point violation there. Do you understand all those charges?
Yes, I do.
The only one that's a misdemeanor is no license. Did you sign, read, and understand the advice of rights? You plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Yeah.
I'll enter a not guilty plea, $500 personal bond. You go sit out in the hallway. He's going to hand this file to the prosecutor. I'm entering a plea of not guilty, pleas of denials, and we will go from there. Okay? Thank you very much.
Let's see here.
Dorton. Rhonda Dorton. 25F724335. Give me 1 second. I think she has another one.
Yep,
25F724335, 25F724425. Good morning, Mr. Selnick.
Morning, Your Honor, Edward Zelenak, appearing before the defendant, Ms. Norton. Please give your name.
Rhonda Lynn Norton.
All right, so we have an illegal entry in 2 counts of illegal entry, it looks like. Illegal entry without permission at 26414 Blue Heron Drive on one case. And the other one is, let me just double check that. It's also 26414 Heron Drive. So does she stand mute? Wait for
Yes,
reading
the reading stand mute, Your Honor.
All right, I'm going to enter not guilty pleas for her.
I would presume, Your Honor, that once the prosecutor looks at this case, it may not go any further, but you may want to put it in the lap of the regular prosecutor. You have a visiting prosecutor here today.
I think Mr. Mohammed might be going to 34th. I think
That could be, and then they'll have someone else here, but that'll be sometime after the first year. It doesn't matter, Your Honor. This is a family matter, and the defendant here is the circuit court conservator and guardian over the father, and this is a sister's garage. And I think once the prosecutor reviews the evidence, because if it goes to trial, bringing the probate court attorney and health protective services. So I think they need the prosecutor to take time and look at the file and decide where they want to proceed. So you pick whatever date works with you, Judge, and if not, we'll proceed. We're going to waive the jury trial, set it for bench trial.
All right, I have to set to. Do you have any bond sheets down there? I got it. Just give me 1 second, if you would, please. These are 2 different offense dates. It looks like it's 3 days apart. So I'm going to just incorporate all of these, Mr. Zelnick.
Thank you, Your Honor.
So on both files, ma'am, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to enter the property address at 26414 Heron, Blue Heron Drive. Blue Heron Drive in Flat Rock. and no contact. Who's Alonda Beatrice?
Her sister.
And you're telling me your client is the appointed?
Guardian and servitor over the father. I don't want to burden the court with the facts of the case, but there's a probate court follow-up hearing coming up in February, but I would like the prosecutor to look at all the facts and the court orders of who has the right to administer medical treatment to the father.
I got it.
So, and this would be a nice holiday story that could be wrapped up with everyone singing Merry Christmas, but I don't think that's going to happen, Your Honor. But otherwise, if you want to set it for the Tuesday before Christmas or after the first of the year, perhaps let things settle in.
All right. Let me just do this. I am going to order. So, ma'am, no contact with Alondra Beatrice. No contact with prosecution witnesses except through your lawyer. You're not to enter 26414 Blue Heron Drive in Flat Rock. You cannot leave the state, cannot violate a law. You must appear in court as directed. I'm going to have to order her to go over to get fingerprinted by 1 p.m. today, okay, on both of these cases.
I'll explain that to her, yes.
And we'll give her the order and the bond sheet. At least I've filled out 2 different orders for prints, but only 1 bond sheet. So we'll give you the date. When did you want?
Well, Madam Prosecutor suggested after the first of the year, but whatever works with the court, we're fine with it, Judge.
Lisa, what do you have for me, Lisa?
January 6th at 1:00.
January 6th at 1:00.
Yeah, I'm going to be handling this. This is going to be Judge Heston's case, but I'm going to be handling that docket that day. I don't know if she's told you, Lisa, but I'm going to handle that docket. But I have an appointment and I won't be in until 10:15. So that's what we'll do. 1 p.m. on that date. You can go down the hall, get your notice, personal bond. You're all set. Wish you well. Good luck.
Do you have any tricks playing out of town before the first of the year? We'll notify.
We should go. We should all leave town with all the snow.
Look outside, Judge. You'll wish it had been yesterday.
I know. Thanks. Good luck.
Thank you.
Okay. Good. Okay. So this is people against. All right. Hang on 1 second. I'm getting all that. There we go. All right. Rodney Sean Tuttle. And I want Officer McParlin here, 25B701485. Good morning, officer. I'm going to ask you to take your hat off. Tell me your name, please.
Yes, Your Honor. Excuse my air. I'm Officer Gage McParlin with the Brownstown Township Police Department.
Names again over here.
John Freeman on behalf of Mr. Tuttle.
Name.
Ron Sean Tuttle.
All right. So one of the things I pointed out, he pled to attempt, resist, and obstruct, 2 counts, a 1 year. And then he pled also to use of methamphetamines, which is a 1 year. And I pointed out, I read in the report where you said he punched you in the forehead. And his lawyer's saying it's on video and he's inviting me to see the video. And I'll be happy to look at the video. But he's seemingly disputing that. He's saying that you tackled him, right, Mr. Freeman? I don't want to put words in your mouth.
So, Your Honor, I just rewatched the video. So my client is getting involved with the man to stop. The officers wanted to speak to him. He refused to do that. And he started to move away from the officers. So I believe it was this officer that's currently on the video attempts to tackle my client. He is the person that initiates the physical contact. My client begins to run. And during the course of trying to run away, this officer loses his footing and falls to the ground. There's a second officer who is involved in the pursuit. This is all visible to me, at least, on the body worn camera footage of the second officer who's a little bit farther behind. I do not see anything on this video of my client attempting to strike.
He didn't say attempting. His report says he struck him in the forehead. That's what it says. And he said, I reached again as I reached out to grab Tuttle's wrist, he pulled away from me. I reached again for his arm. Tuttle punched me on the right side of my forehead. I lost my balance and fell down to the ground, and Tuttle took off running northbound on Kirby. And then he talks about how he and Officer Grimm tackled Tuttle to the ground on the cement driveway. While Tuttle was on the ground, he continued to fight with me, resisting arrest. Grimm and Novak, fighting with me, Grimm and Novak. I personally had to knee Tuttle in the ribs to get him to surrender his hands. I also attempted to strike Tuttle on the shoulder, but he moved and I struck his face. After 2 minutes of fighting / resisting, we were able to handcuff him and place him in an upright position so he could breathe. So I'm just asking you, because I'm going to look at this video.
Yeah.
Did he in fact punch you in the forehead?
Your Honor, I remember being struck as I went to grab Mr. Tuttle, and at that point I fell. That's what I remember. If the video shows anything different, that is just, I would like to see it as well, but that's exactly what I remember, and my video camera fell off. But that is exactly what I remember.
Can I see the video?
Of course.
All right, you want to pull it up here? Can we, he's got it on his podium here, at the podium, Lisa. Can we, tech savvy, I'm not. Can I get it up on the screen there, or?
I'd also be happy to step up and kind of facilitate the court. Watching it on my laptop, there is some audio to it.
Yeah.
If he wants to join the Zoom, he can do a share screen, or he can send it to me and I'll share screen.
I think Brian's joining the Zoom.
Okay, let's have you do that. I'm sorry to call you on such short notice, officer, so just bear with us if you will, please.
Not a problem, Your Honor. I don't want to be wrong in this case, so please, yes, pull it up, and thank you for calling me.
No problem. I hate to do this, but while you're doing that, I'm going to go on to another case here, okay? Mark Charles Matthews, 25X4620326. And this is Officer, Trooper Harba, and it looks like he's not here. Mr. Matthews, your name? Mr. Matthews?
I'm sorry, I was muted, Your Honor. Good morning.
Your name?
Mark Matthews.
Okay, just stop walking for 1 second.
I'll
get you out of here. The officer didn't show up. I'm sorry it took us so long to get to you. I had something come up this morning, case dismissed. You're all set. Have a nice holiday.
Thank you, Your Honor. I appreciate it.
Carson Matthew Morrow, 25M615488. Have a good one, Mr. Matthews. Trooper McLaughlin.
You as well.
Carson Matthew.
Hello, Your Honor.
I'm going to ask you to take your hat off, Mr. Morrow. And tell me your name, please, Mr. Morrow.
Carson Matthew Morrow.
And Trooper McLaughlin, your name, sir?
Yep. Good morning, Your Honor. Daniel McLaughlin.
Good morning to you. Okay, so he's got a clean record. You got him going 91. You wrote him for 85 and a 70 limited access. Any offer here?
Yeah, I can do 1 to 5 limited access if you'd be willing to accept that.
So, Mr. Morrow, he's offering you to plead to 75 and a 70. If you do that, it's 0 points, but it will go on your record. Do you understand that?
Yes, Your Honor.
Do you want to plead to that, or do you want to have a hearing on the 85 and a 70?
I would like to plead to the 75 and a 70.
All right. To the charge limited access, 75 and a 70, responsible or not responsible? You plead responsible to 75 and a 70?
Yes, Your Honor.
I'll accept the plea. 150 is your total. You can pay that today, can you?
Yes, yes, I can, Your Honor.
33court.com, okay?
Awesome. Thank you, Your Honor.
Have a great Christmas. Do you have
Yes,
any more, Trooper? I don't. I don't think
believe
so.
so. I don't believe so. I think it was just Mr. Morrow.
All right. Well, have a great Christmas if I don't see you, sir. Thank you, both of you.
Yes, sir. You as well.
Yes.
I'll see you. I'll see you on the 15th.
Okay. All right.
All right. Take care.
Thank you.
You guys have a
Thamer,
good Christmas. Yeah.
thank you.
Have a good
Thamer
one.
Matham Al Yawi, 25M 6044474 A, B, and C. Prohibited holding. I don't know what that means. Counsel, your appearance. Good morning to you. How are you?
Good morning, Your Honor. I'm standing in for the attorney record, Mr. Samuel Jadallah and Larry.
Oh, no, I don't have yours. I'm sorry. That isn't the one I called. Counsel, your appearance.
Good morning, Your Honor. Attorney Amir Al-Khalidi on behalf of Thamer Al-Alyawi.
I want to make sure I'm reading this right. It looks like I'm dismissing the expired plate and the no proof of insurance. And then the defendant's going to plead to impeding. And I don't know what she means by prohibited holding. Is that operating a text?
Yes, it is.
Text? So your client's going to plead as charged as to count 3, operating while texting, right?
Correct.
And then where am I putting the impeding? I don't think it really matters, but
We're just count 1, 2, replacing it with, count 1 could be impeding.
Right. So count 1, he'll plead to impeding. Count 3, he'll plead as charged. And original charge on count 1, expired plate dismissed. And count 2, no proof of insurance is going to be dismissed. Am I reading that all right?
Yes, you are.
Okay. And you're authorized to enter this plea on behalf of your client, right?
I do, Your Honor, yes.
All right. As to count 1, impeding traffic, responsible or not responsible?
Responsible.
As to count 3, operating while texting, responsible or not responsible?
Responsible.
Okay, I'm accepting the plea to impeding on file 1, A, count 1. I'm accepting the plea to operating while texting, file C, count 3. All right. And then I'm going to just, I'm accepting the plea to impeding on count 1, accepting the plea as charged on count 3, dismissing no proof of insurance count 2, and dismissing expired plate on count 1. I'm going to assess fines and costs on the C file of $210. Really, the expired plate is what they're putting for the impeding, so I'm only going to charge $100 on that. So your client owes $310. Can your client pay that today, or does he need time?
Can we do 14 days, Your Honor?
No problem. Yeah, pay by the 23rd of December. I'll just make it, okay?
Sounds good. I appreciate it, Judge. Thank you.
Have a great day. Thank you very much.
Bye-bye.
All right. Okay. Now we're going back. Give me 1 second. Now we're going back on Tuttle. All right, recalling Rodney Sean Tuttle, 25E701485. You and your client can sit right there, counsel. You don't have to stand at the podium. Come on over and sit next to your lawyer here, Mr. Tuttle. And Officer McParland, I just want to make sure you can see this as well. You can see this?
Thank you, Your Honor. Yes, I can see it.
Okay, you can go ahead and start the video.
So, Your Honor, I'm not sure about the audio part because there was some feedback. So I don't know if the courtroom has to be muted. I assume the court wants to hear the audio.
Yeah, let me see that. Let's, if we have a problem, I'll tell you to stop it, okay?
So, Your Honor, I can hear it here, but I can't, I don't know.
I'm here, I'm able to hear it a little bit.
Your Honor, is it lagging on your end?
It's not the best. Where's that coming from?
From my, his left hand.
I should have paid attention in typing class. Okay. I don't even know how to mute myself. See, I mean, there's part of this that's weird. We got the audio already muted over here. Okay, try it now.
You're already muted.
All right, I'm just going to watch it. Just let it go for now. Keep it going. Whoa.
Yeah, we can. So good luck. Okay, talk to us. So we don't need actually to go to over. You're going to let that try. We have to talk to you. Okay, what is it? Why did you get more time?
Your Honor, I think that the critical part is what we just watched.
Yeah, I want to go back. I want you to turn it back about 15 seconds. Can you see this okay, Officer McFarland?
Not at all, Your Honor.
Go ahead, play that.
Trying to get your time.
Yeah. All right. You can approach the podium and let's finish the sentence. Officer McFarland, you are the victim on this. You are welcome to tell me whatever you'd like to say.
Just one thing for clarification, Your Honor. Again, the video I can't really see very well, but I don't want to put or make any statement if I made it wrong or whatever. Did you see him strike me? I cannot see the video.
It looked to me like he did. At one point, when you went toward him, it looked like in the process of him trying to get away that he did take a swing, but I'm not positive about that.
All right, just because I don't want to be an officer known for any kind of like someone think I just falsified anything here, because if I'd set the record straight. But continue, Your Honor.
Nobody thinks that. Okay.
All right. Yes, Your Honor. I appreciate that.
Do you want to say anything else?
Mr. Tuttle, if I could speak directly to him, if at all possible, Your Honor.
Sure.
Or to the court. Mr. Tuttle, despite what happened, sir, I really hope you get the help you need wherever you're going in life. All right, buddy. I know you've seen. I know you were on Allen Park. They had an incident there. I wish the best for you and your family. Okay.
Appreciate it.
Not a problem, man. Good luck, brother.
Can I have 3 probation orders? Counsel, what else would you like to? You're free to sit there if you want still. I don't have any problem with that.
It feels awkward, Your Honor, for all the years I've been.
I get it. I get it. I'm sorry. I didn't mean lose. I'm not the probation orders. I'm sorry. I'm not probation. Yeah. Orders of probation.
So, Your Honor, since I first started interacting with my client back months ago when I was hired on this matter, my sense is that he's been doing everything right. He was living in Florida after this event, and he went through a rehab program there. He was working gainfully employed with Amazon. And he just seems to be on the right track. And I'm really concerned that ultimately, if he has to do the incarceration, that it's going to derail the progress that he's made. So I'm going to ask the court to follow the recommendation. My client has relocated to the state of Kentucky where he's got stability and living better.
So he's actually living in Kentucky now.
Yes, Your Honor. We started out in Florida. We came back here. You may recall there was an issue about him needing to have his fingerprints taken.
Yes.
Did all that. He's been here for the 2 in-person court appearances. So now he's residing in Kentucky with his dad, where he's working. We have no objection to the recommendation. I think it's very fair. I think that addressing what's going on underlying with Mr. Tuttle's behavior is going to be the key to success. And hopefully he never has to appeal for a judge like this again. He recognizes that he's got to do a lot of work in order to make sure that that happens. And I would just ask the court to follow the recommendation, give him the opportunity. Your Honor, the court also, the last time we were here, directed him to appear or to attend AA meeting.
Yeah, because he wasn't doing it, right?
That's correct. And I do have, he's got a sheet here that's been signed that shows consistent meeting attendance between November 15th and December 7th. So I can provide that to the court.
No, I trust you, counsel. I believe you.
Your Honor, I think the video speaks for itself. I think the court has a clear grasp as to the facts of the case. And I'd ask them to show some mercy to my client.
Mr. Tuttle, anything you'd like to say, sir?
I apologize for the situation. But the best is on board on both parties.
I'm sorry?
I hope for the best on both parties.
Are you going to be in Brownstown area at all?
Okay, here, why I'm saying my father.
All right, 18 months probation. You cannot leave the state without the consent of the court or violate a law. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. No alcohol, no drugs. Stay away from that meth. No alcohol, no drugs of any kind, not marijuana, anything. No alcohol, no illegal controlled substances, no marijuana. You can leave the state to go to Kentucky. You're not to purchase, possess, or consume alcohol or drugs. You're to submit to chemical testing, PBTs and ETGs as follows. I'm going to make it weekly for 2 months. If you're clean, I'll make it bi-weekly for 2 months. If you're clean, I'll then revert it to monthly. Okay? Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Again, you're to attend AA, NA 3 times a week until I think he needs intensive outpatient treatment counsel. I really do. He's got too much of a history here. So 3 times a week until an IOP. Once you get into intensive outpatient treatment, you no longer have to attend AA or NA. Okay. Do you understand all of this so far?
I really don't understand what intensive outpatient is.
All right. Well, it's more than once a week. They're going to be having you go 3-4 times a week. Okay. And probation will explain that, and your lawyer will explain that. I think he has 1 day credit coming from the arrest. Is that true, or does he have more than that?
I think it's just.
Okay. All right. I would make him do the court work program, but I'm not going to since he lives in Kentucky. 10 days jail, credit 1, serve 9. I'll let you serve 9 days of community service. That has to be completed by February the 20th of 26. In terms of fines and costs, and on count 1, I'm going to attribute everything. $100. What happened? $100 fines. 75 costs, $60 screening fee. That is $235. Probation fees are $360. That's $595. And then you have 75 and 50 for 75 victim choice fee, $50 justice assessment. So that's another $125 on top of the $595 for a total of $720. I believe on the other 2 counts, I'm just assessing 50 and just the justice assessment fees. So $100 fines, 75 costs, $50 justice assessment, 2.25 on both of those other files. Okay, so 100 fines, 75 costs, and $50 justice assessment. So that's 2.25 on those. I'm not going to charge you again, or 365 days. All of these terms and conditions are running concurrent. Do you understand that, Mr. Tuttle? All right. All right. So counsel, he owes $720 plus $450 or $1170. Can he pay all that today?
Your Honor, would the court consider a 2-month payment plan?
I don't have a problem with that. Okay, so let's just do this. Just give me 1 second. There's a lot of paperwork here. Oh, boy. Monthly, weekly. All right, so how do you want to be able to pay this, counsel? In other words, why don't we set up a payment plan and
would it be easier if the court just set a due date for?
Yeah, I'd rather have them do that. I'd rather set up a weekly or bi-weekly or monthly or what have you. So how much can you pay weekly, sir, or bi-weekly? Can you pay $100 bi-weekly?
Yeah.
Well, let's just do that. $100 bi-weekly beginning December 23rd. And then you just pay every other week. If you don't have the money, call the court. We'll go on Zoom. I'll give you an extension. We're not going to have a problem. Just don't ignore me, okay? You'll meet with probation before you leave. Any questions?
Probation paying, just out of curiosity on how
You're going to talk to probation. They're going to have you test in Kentucky. You don't have to drive back to Michigan. And yeah, they'll answer all your questions. And if they don't, you can come back in here and ask me, okay? Anything else?
No, thank you.
Have a nice day. Take care. Enjoy your Christmas and everything. Thank you. I know I've got people waiting here. My mistake. Jason Snook. I'm sorry, which one do you have?
I have Catherine Messner. We're simply asking for an adjournment.
I'm sorry. Can you find that for me, John? Jason Snook. Jason James Snook, 225M624910. Okay, counsel, you're just having him plead to one count of impeding, right?
Yes, Your Honor.
Okay, because you got two impeding or something, it looks like.
Which one is this one, Your Honor?
Jason Snook, it's only one count though, Shelby Township.
Good
morning, counsel. Ms. Lee.
Good morning, Your Honor. Attorney Amber Lee, P84377.
Is this just one count? You want to look at this?
This is the.
Your appearance?
Nathaniel Eisner on behalf of the people, P88493. This is the ticket where the individual was written up for 6 to 10, but it was 25 miles per hour and he was going 19 over. So we agreed on 2 impeding as opposed to 1.
The problem is we can't really do that.
Okay.
Without you issuing another citation. I mean, the state has their ways of, I'm pretty sure that's the way we're still doing it. So,
We can amend it to 1 then.
okay, so one count of impeding.
Yes, Your Honor.
Yes, Your Honor, my client does want to plead responsible to that count of impeding traffic.
So there's just gonna be one count. You guys talked about 2, right?
Yes, Your Honor.
All right, you're authorized into this plea on behalf of your client to a one count of impeding?
Yes, Your Honor.
To that charge on behalf of your client, responsible or not responsible?
Responsible.
Please accept it, 150. I'll give them until the 16th to pay, okay? 33court.com, all right?
Okay.
Thank you.
Thank you, Your Honor.
Catherine Alicia Rose Messner, 25I-724-704. All right. We're going to set a final pretrial here, right, Mr.
Good morning, Judge. John Graziani, appearing on behalf of Catherine Messner, P number 43387. That's correct, Judge.
Do you think this is likely to resolve or not? Because
Judge, we do believe we'll resolve this matter and
good enough.
we're asking for
The 23rd.
That's
Lisa, what do you have on time wise for me that day?
9:30.
At 9:30.
I'm sorry, what's the defendant's name on this one?
It's Catherine Messner, MESNER.
Got it. Thank you.
Okay, ma'am, your name again?
Catherine Messner.
So you can go down the hall and get your date, the 23rd, all right? Have a great day. Tricia Lynn, thank you, you too. I'm sorry to have kept you that long.
No, Judge, I'm fine. I'm here.
Tricia Lynn Ely. Did I get this one yet?
Judge, I haven't dealt with Miss Ely. I don't know.
Okay, I'll pass it. I'll pass it. Tatiana Richardson.
Ready, Your Honor.
4B703477.
Good morning, Your Honor. Judith Brady on behalf of Tatiana Richardson, P44567. Ms. Richardson, state your name for the record.
Tatiana Richardson.
Okay, wait a second. I'm gonna have a little bit of a problem with this. I'm ending my state docket here, the end of the month. I gotta move this out. You had an adjournment. We adjourned the PCC from the 2nd. She was arraigned November 21. We adjourned the PCC from the 2nd to the 9th. I mean, it's possession of a financial transaction device. I don't want to go any further than this. Are they here the 23rd? Lisa,
Yes.
the prosecutor's office?
Yep, we're here the 23rd and the 30th. Well, you're not here the 30th though.
Yeah, so I'm gonna set it for 1 week out, but I can't, the PCC, I'll do that for you, and I'll adjourn the exam to the 23rd, but I can't do better than that, okay?
Can you repeat that, Judge, please? The dates?
Yeah, the 16th, I'll do the PCC. I'll give you another date on that, but the exam's gonna have to go on the 23rd.
Okay. All right, Judge.
All right, where is Ms. Richardson? You already waived your right to have the probable cause conference, I believe, within 14 days of the date of the arraignment. Your lawyer's asking for an adjournment. She wants me to adjourn this to the 16th. I'm willing to do that. But that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes.
Do you waive that right?
Yes.
All right, so we'll do the 16th at what time, Lisa? 9 o'clock or something, 9:30?
9:30.
And then the 23rd at 10 o'clock. How's that? But that's going to be in person. No more adjournments, please. Okay? So that's what I'll do. The 16th and the 23rd. Anything else, Ms. Grady?
Nothing further. Thank you, Your Honor.
Have a good day. Thank you.
You as well. Thank you.
All right.
In county jail, join the breakout room. Judge, your camera's off.
Well, we don't have to see my ugly face then. That's better, isn't it? Okay, hang on. What's going on with this? All right. What am I doing now? I'm sorry. I feel like I'm got files all over the place here. Shannon Feelhauer. Well, wait a minute. Let me get Mr. Counsel. I'm sorry. Let me get you out of here. I'm not setting this for a formal hearing on January 30th. Are you kidding? What's this?
Your Honor, this is for a plea negotiation.
No. Come on, guys. This is a prohibited term. Are we talking about Larry Del Jesus Zavalita Noriega?
Yes, Your Honor.
25W840708. I can't. You guys are. Yeah, you can't. I can't adjourn this for 7 weeks. This is a prohibited term. What do you mean? Come on.
Any day that the court finds a good day for a formal, Your Honor.
What's that?
There's no offer. We would agree to any day that the court finds acceptable.
This December 23rd, we'll have the formal hearing.
December 23rd. Can we do Zoom since it's going to be resolved anyway? We just want to see what the trooper has to say, Your Honor.
What is this another? Is this another one of those commercial vehicle cases? It is, isn't it?
Correct.
I mean, if you're not going to conduct the hearing, I don't have a problem.
Thank you, Judge. What time?
But if you tell me you're going to conduct the hearing, I got to have you here in person, okay?
Understood. I'm standing in for the attorney record, Mr. Sam Jadala. That's the instructions he gave me. He's going to be negotiating on that day, Judge.
But I just want to be clear. I can't conduct the formal hearing by Zoom. If you guys want to, so it's either going to be a plea or he doesn't show up, whatever happens. December 23rd at 9 o'clock, okay?
All right. Thank you, Judge.
Thank you.
You have a wonderful day. Thanks a lot.
Thanks. Shannon Feelhauer.
She's in a breakout room with her attorney.
Okay. Justin Cole. Justin Edward Cole, 25E149451 AB, and I also have, let's see. Good morning, Mr. Cole. Your name? All right. So as I understand it, you're going to plead to impeding traffic. They are going, that's on count. I guess it's on count 2, right? Count 2, you're going to plead to impeding traffic. and then impeding on a bicycle, and then they're going to dismiss. It looks like you took the course or what have you.
Yes, Your Honor.
They're going to dismiss count 1, which is failing to disclose possession of a concealed pistol, and count 3. Count 3 will be dismissed as well, correct? You were supposed to be here in that last week. Why weren't you in here?
So when you adjourned it, I never received anything in the mail besides a court date saying the 25th, which I was already here on 25th. So I had.
Well, I know, but it was scheduled for 10 o'clock. You weren't scheduled to be down there till later, were you? You got to be careful.
To be weird.
Well, you were in Judge Hesson's.
Yeah.
But you didn't have that didn't start till what, 11 or 11:30 or something, wasn't it? Anyway, you got to show up to the charge impeding on a bicycle, responsible or not responsible.
Stop.
I'll accept the plea. I'm dismissing count 1, file A, motion of the prosecutor, and I'm dismissing count 3 on motion of the prosecutor. 150 is your total. You go down the hall and pay that, and you're all set. Good luck. How much time do you need?
You use that person to pay that?
Yeah. January 5th. If you don't have the money, no problem. Call the court. We'll go on Zoom, or you can walk in here on before the due date, 8:30. I'd be glad to give you an extension. Okay. Have a good Christmas. Good luck.
You too.
All right. So which one do you have?
Should be that one, Your Honor.
Which one?
Sally.
Okay. Sorry about that.
Miss Patillo is here also, Judge, for Williams.
I got everybody showing up. Abdul Rahman Ibrahim Al Masawi, 25M615594. All right, counsel. Good morning. Your name?
Good morning, Your Honor. Rami Najazi, P82830 on behalf of Abdul Rahman Ibrahim Al Masawi. It's a long one.
That's okay.
Your Honor, this is the time it gets set for a formal hearing. The prosecutor couldn't get in contact with Trooper Latricia DeBose. She attempted twice, so she wrote it as a dismissal. It is about 50 minutes after the time, so I asked.
Yeah, I mean, it was scheduled for 9:30 and it's 10:22 or something. So I'll go ahead and dismiss this. You're all set. Have a nice holiday and everything. Okay. Thank you. Okay, so I got Fieldholler.
I think you're also ready on Balin.
I got Let's Go. I got Lint. Jeez. Which one did you want me to call, Lisa? Is it Ferris Arslan or?
No, they're ready on Balint, and they're ready on Williams, Christian Williams.
Stephen James Balint, 25I718829.
Good morning, Your Honor. Michael A. Carmen, P73824 on behalf of the defendant.
Good morning. Brittany Maddox on behalf of the people, P83204.
All right. Let's see here. So what are we doing? Where's Mr. Balint at?
He's on
He should
Zoom,
be-
Judge.
Mr. Balint, your name?
Stephen James Ballant.
All right, so I set a PCC for today. There's no, what are we doing?
Your Honor, we're asking for an exam to be set, I believe, next Thursday, the 18th at 1 o'clock, please.
Am I good that day, Lisa?
Good that day.
I am?
Yes.
All right, so counsel, Ms. Maddox, you ready to go on that day?
Yes, Your Honor.
All right, so we're going to have it December 18th at 1 p.m., okay?
Thank you.
And we'll see everybody here at that time. I'll ask you to make sure you're here on time, please. Thank you very much. Have a great day.
Thank you, Your Honor. See you then.
Thank you. Is Ferris Arslan out there yet?
He's not on Zoom, Judge.
Which one are you here on, Ms. Patillo?
Christian Williams, he says he's in the waiting room. Oh, I see him. He's there.
Okay, I'll take that one. Christian Williams. Christian Williams, 25M 716-8821. Mr. Williams, your name?
Christian Williams.
Dion Patillo, P82378 on behalf of Mr. Williams. Judge, today is going to be a waiver of the preliminary exam.
Is that what you want to do, Mr. Williams?
Yes.
You are charged with the false pretenses, 1,000 or more, up to 20,000. That's a 5-year felony. You have the right to a preliminary examination. At that exam, the people would have to show that that crime was committed and that you were the one who probably committed the crime. By waiving your right to a preliminary exam, you're waiving that requirement. You will automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes.
Is that what you wish to do?
Yes.
Anybody force you to give up your right to an exam?
No.
Waivers accepted. You're bound over for further proceedings to the Wayne County Circuit Court. The AOI date will be on the 23rd, and that will be it. You are all set. Bonds continued. Anything else, counsel?
No, Your Honor. Thank you so much. You all have a good day.
You don't have any more with me, right?
Nope. That's it for today.
Have a great one. Thank you.
You too. Thank you.
So thank you.
Thanks.
So I've got Peel Holler with Joy Mohammed, and I've got, let's see here. I got Ferris Arsland. Did he ever show up?
He never checked in with me.
The attorney is in the breakout room, but I have not seen him.
He didn't check in with me.
I think, didn't he take a bus last time and showed up late? Was that him?
I don't remember. He was supposed to be here at 9:45. Is Jacob Joseph Lesko out there?
Yes.
Okay, 25M601345. Is Trooper Hadzik here?
No, he's not.
All right, Mr. Lesko, your name?
Jacob Lesko.
So you were here on the 25th. I set aside the default judgment, right?
Yes.
You want to present your case?
Yeah, I got pulled over.
Listen, I'm just messing with you. The officer's not here. Case dismissed. You're all set. I'm sorry.
No,
I gotta laugh a little bit up here. I'm dismissing the case. We're gonna refund the bond money to whoever posted it. Did he post it, Lisa?
We'll return it. We'll send him a check.
Yeah. Well, it's Ashley Quint it actually was posted by. So you should have Ashley Quint, unless we have his address or her address, I should say. That has to go to Ashley Quint. So why don't you ever call the court at extension 230, please, okay?
Okay.
All right. Any questions?
I don't believe so, Your Honor.
Have a nice Christmas. Good luck. Thank you.
Thank you. Merry Christmas.
Thanks. All right. Who do I have in front of me here now? I have, let's see.
Attorney Joy Mohammed for Shannon Feelhauer.
Yeah, okay, Shannon Feelhauer, 25T7288822. All right, your name.
My name is Joy Mohammed, P87246, and I'm here with my client, Shannon Feelhauer. Shannon, please state your name for the record. It's unmuted, Shannon. You can just talk.
Nice and loud for me, ma'am.
I'm sorry?
Nice and loud. Tell me your name, please.
Shannon Feelhauer.
Okay, we can't just adjourn this a week. I'm done with the state docket.
Actually, we don't need to adjourn it for a week. I think we can set this for exam today, if that's fine.
Okay, you want to just go to exam next Tuesday?
Let's do that. And let me double check my calendar.
Your appearance?
Joy
on behalf of the people who gave me.
All right. Are you going to be my new prosecutor?
Not sure yet. Mohammed's still on vacation, and he should be back next week.
How long's he gone?
He's gone until, so he should be back the 15th, which is on Monday, I believe.
Nice.
Yeah. But I know you mentioned Robin's same day.
Right.
Somebody else would have. Then I have my countdown on Tuesday, so why I think it might be me.
Okay. Are you ready to go? So you want me to set this for next Tuesday?
Actually, next Tuesday, I'm in to.
Nice and loud. I'm having a hard time hearing you kind of.
I'm sorry. Is this better? Hold on.
Yes. Yes.
Okay.
So we can do it the 23rd. That's fine.
Let's do that.
All right, ma'am, you have the right to a preliminary exam within 7 days of the date of the probable cause conference. Today's the probable cause conference. Your lawyer is not available next week. She's asking me to set it for the 23rd. You waive your right to have the preliminary exam within 7 days of the date of the probable cause conference.
Yes, I do, Your Honor.
Anybody force you to do that?
No.
December 23rd, is 10 okay, Lisa, or you want another time?
How about 10:30?
10:30, okay? The 23rd at 10:30. We will see you here then. Thank you very much. Have a good day, everybody.
Thank you. Now, before you pull the next case, I have that Lorenzo Whitfield. This is a show cause. Am I supposed to have this file?
Let me see
I
that.
don't think I can offer on it. He didn't show up last week. It's a ticket, but he's here today. I'm done. I just want to.
Oh, well, what happened is I arraigned him, so you could just negotiate this.
It said show cause on it, so I'm.
Because what happens is the state has decided that we need to show cause everybody before we issue warrants. Just another step, a lot of paperwork and postal and
Okay.
manpower. Yeah, you can make an offer.
Thank you.
Thank you. All right. Sure. I'm gonna issue we don't have Ferris Arslan's phone number, do we, by chance?
I'm not sure. I can bring the attorney in. She was just appointed because remember he requested a new attorney.
Ferris Arslan, 25W7275583. Good morning again, Ms. Tucker Davis. I'm calling Arsland.
Yeah, I'm ready, Your Honor.
All right. Good morning. Your appearance?
May it please the Honorable Court, Don Tucker Davis, P 59229, representing Mr. Arslan.
Do you have his phone number?
I do not have a phone number and I could not read the address correctly. Is Mr. Arslan present?
No, but somebody told me, was it you or somebody told me that, I don't remember if it was my recorder or judicial clerk said that he showed up late because he took a bus last week. Can you check back in here at 11 o'clock or so? But I got to issue warrants on this guy. This has been going on. I had arraigned him November 11th. We've adjourned this a couple times. He fired his lawyer, or at least they had a breakdown last week. So I don't mind waiting for him a little bit. You want to just check back in around 11?
I do. I would like to give Mr. Arslan every opportunity. Thank you.
Represented by Ms. Shy, we have Mr. Harrison, the prosecutor's office, rose from probation. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
We have 229 days of jail time credit, restitution in the amount of $31,441.71. Does that sound right to everybody?
That is correct to Odessa Auto Auction.
All right, Mr. Any reason not to go forward with sentence today?
No, Your Honor.
All right, Mr. Harris, on behalf of the state.
Your Honor, there was another victim of this matter, actually, and a potential other. The one individual that suffered injury, personal injury, as well as property damage, as the end result of this was a head-on crash. She is going to sue, is intending to pursue this civilly. She has an attorney, and they're doing that in this matter. But there was other damage, potentially substantial damage, medical expenses, as well as property damage. Your Honor, in weighing the factors, the purposes and principles of sentencing, that being to protect the public, risk of recidivism, and also not to demean the seriousness of this offense. State notes the defendant has been to prison before for similar activity, and it wasn't that long ago. So definitely he's proven to be a high risk of recidivism. Certainly that factor is met, in that he has not learned from his mistakes. I think it's evident of that. There was a serious risk of serious physical harm to an individual of Odessa Auto Auction who attempted to stop the defendant and his co-defendant from leaving. And in that, the facts played out, and he could have seriously been injured. Luckily, he was not. Defendant fled in this vehicle. Co-defendant jumped in. They led police on a pursuit, as the court's aware, ending in a head-on crash to an innocent motorist. So certainly, this is a public safety issue at this point. We believe the defendant, there's really no option but prison. We would ask that that prison sentence be fashioned and more serious than the last time he was to prison in order to change the behavior in the future. Thank you.
Ms. Rose, anything from probation?
No, Your Honor.
Ms. Shai?
Yes, Your Honor. Considering the purposes and principles of sentencing, the court is to also consider treatment and rehabilitation. My client has never participated in substance abuse treatment nor mental health treatment. He was under the influence when this occurred. His prior was in 2023. It wasn't long ago, but other than that, he does not have that much of a criminal history. I would venture to say that maybe something is going on with him and within the past 2 years, and that his need for treatment is essential here. He is only 23 years old. So we would ask that the court consider his treatment and rehabilitation efforts. Thank you.
Mr. Mahmood, anything you want to tell me?
Your Honor, I take full responsibility and accountability for what I did. I regret what I did, not because of the fact I got caught, but because of the fact I could have seriously injured somebody. And I'm really sorry about that. I'm sorry, sincerely sorry to the victims. I want to say sorry to them. I know this is not the first time I committed this crime, but I just want to ask for another chance. And I'm ashamed for what I did. Because now, for a long part of my life, I'll be labeled as someone that likes to rob people and someone that does not follow orders. And it's gonna be hard for me. I want to ask you for if I can actually get into a treatment program. I've been to prison before, and that didn't work out for me. I want to go into a treatment program so I can better myself and be there for my family. Thank you, Your Honor.
I mean, I get what you're saying, Mr. Mahmood, about the issues regarding your treatment, drug, alcohol abuse, all that. This is a protection of the public in a punishment case. And, you know, it's not that long that you were in prison for the same thing before. I find you're not amenable to community control. I'm going to sentence you to 18 months in prison on each of these charges, that being the robbery and the failure to comply. I'm going to order that they be served consecutively, meaning one after another, for a total of 36 months in prison. I'm not going to impose a fine. I am going to impose the cost plus the $31,441.71 to Odessa. And I'm going to suspend your license for a period of 8 years. This also includes a mandatory period of post-release control. You are going to be supervised by the Adult Parole Authority for, for anywhere from 1 to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. That's automatically consecutive to the sentence that you would receive for the new felony. You are on post-release control now. But I declined to impose any of your PRC time. That doesn't mean that the Department of Rehabilitation and Corrections might not, I don't know, but I think 36 months is the appropriate sentence, and we have 229 days of jail time credit. Anything else?
No, Your Honor, thank you.
All right, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. Good luck to you, Mr. Mohammed.
Court recalls the case of Riverside Apartments versus McKinney. James Swing for the plaintiff. Your name?
Tashara McKinney.
We have had an opportunity to discuss the matter in chambers. And plaintiff has submitted an order denying the motion to set aside the default. Have you had an opportunity to read it? She has not. She has not. Okay. Basically, the terms of it are, and I'm going to give you an opportunity to look at the order. That what came out of the discussion is that I'm going to deny your motion, right? That the eviction order, which they've already submitted to the court, on or about shall be issued and ordered immediately, and I will sign off on that. And that the escrow of $1,147 that's held by the court will be released to the plaintiff immediately. And that you shall pay $2,000 in rent on or before December 22nd, 2025. Correct? You'll comply with all terms and conditions of the lease and shall not cause any disturbances or harass other residents of the building. The order of eviction shall not be executed before December 23rd, right? But if you pay the $2,000 on or before the 22nd, complies with your lease, not cause any other disturbances or any other harassment of other tenants, the order of eviction shall not be executed on or before January 2nd, 2026. And I'm just going to make that change there.
Did I say on or before there?
You said shall not be executed before January 2nd, 2026. I had to change the 6, the 5 to a 6. If you don't comply with the order, plaintiff shall initiate an order of eviction by filing an affidavit of noncompliance with the court and sending copies to yourself and also to J.F. Moore and Associates who would conduct the eviction. You understand that, ma'am?
Yes, Your Honor.
All right. And neither party is waiving any claims to the lease under the Landlord-Tenant Relationship Act. Before I sign off on this, I'm going to have them give that to you so that you can take a look at that and make sure that that's correct. And if you need time, I'll pass it real quick. I've got another case at least that I can call. I did.
Yes.
All right, give me that $5. Hey, Ms. McKinney, you have any questions about it? Any misunderstanding?
I do not, Your Honor.
All right. And while it may not be the best for you, you think this is going to work out for you?
Thank you.
All right.
Could we get copies today, Your Honor?
Yes, you can. And I have signed it. Ms. McKinney, good luck to you.
Thank you, and I hope you have a happy holiday.
You do the same.
Thank you.
We have a hand make copies of it. That's sometimes. Yeah. All right. Did you want a copy also?
Sure.
All right. It'll take a few minutes, but we'll get it out to you. Just have a seat and we'll get it. Pleasant Lake Apartments versus Christopher Genowak.
Good morning, Judge David Morse for plaintiff.
Anahuac, they are not here, counsel. Like a default.
I would like a default, Your Honor. Before requesting a default, I want to inform the court that there is a second pending case, and that was filed by plaintiff, so I don't mean to cast aspersions. And so I believe that to be the scheduling error because he has been participating. I wanted to bring that to the court's attention.
So
Mr. Mahmood's license for life pursuant to the statute.
And then as far as the other charge, we had discussed 30 days concurrent on.
Yeah, 30-day concurrent sentence on the misdemeanor. All right, anything else?
No, that was it, Your Honor. Thank you.
All right, that's all.
Plaintiff filed another case.
Correct, Your Honor. Separate and independent termination of tenancy based on the actions that have come about. That is scheduled for a second hearing on Friday. And I think that's just on the forefront of his mind is that hearing. And I think that pushed this out of his mind. And so I think he's worried about Friday.
Got it. Okay.
So if Your Honor would like to push this to Friday and deal
I
with.
really wouldn't, but I will.
I think that it will come out on Friday.
Yeah, and thank you for saying that, counsel, because then if I issue a default, what's going to end up happening is it's going to be set aside because he's going to say he had this other.
Correct.
All right, I will put this over there, although we're on Tuesday. I will put this over to Friday,
No. 12.
So I'll adjourn this to this Friday. Well, 2025 at, do we know what time that is?
Yes, Judge. $2 p.m.
2 p.m. All right. So I'll set it at, that's a 12 at 2 p.m.
Thank you.
Thank you, sir. And Chirac versus Ford.
Good morning, Edward Mall, MAHL P27115 for Mr. Sherrod.
All right, and this is the defendant's objections to garnish.
That's correct.
And is defendant here?
Apparently not.
Ford. The only indication on her motion is that the judgment's been paid and you're representing the court that it's not been paid. Is that correct, counsel?
That's not, yes, that is, his statement is wrong, and we show a balance of $1,062.57. We show total payments of $701.24. So I'm sure he's not taking into account interest and costs.
Got it. All right. Yeah, should be objection. The objections to the garnishment are denied.
Thank you.
Court calls the case of Anderson versus Lyman. We have both matters being called.
Apologize for that interruption.
Not a problem. State your appearance, please.
Good morning, Edward Mall, MAHL P27115, attorney for the plaintiff.
All right, where are we on these cases?
Good morning, Judge. My furnace had went out this morning. Not only did my furnace go out, Lori showed up to my house last month and had some guy walk around the back. But when he saw the camera, he ended up leaving.
What?
When the guy she had moved to the house saw the camera, he ended up leaving. And she's still sending falsified information about the case to the water.
To who?
The water department.
So somebody last week showed up to your house?
No, that's a video of him walking around the house.
Did you send somebody to the premises?
No, certainly did not.
She was in the car.
She was what?
She was in the car. You can see it in the video.
And Ms. Anderson, you're indicating you didn't send anybody? So she had a video of that, that would,
I didn't send anybody to the house.
were you at the house? Were you in a car near the house?
And about a month and a half ago, I think I drove by one time, but I didn't drive to the house. I think I just.
Was the car sitting there, ma'am?
Yeah, the car was sitting out front. They pulled up a little bit.
Out front of the house?
They tried to get out the view of the camera. And then he proceeded to look at the camera. And then he walked around the house and then he seen the camera and then he went back to the car and they pulled up. So he didn't finish walking around the house because he seen the camera.
You have that video
Yes, it's in my camera roll.
on your phone?
Yes.
Did you bring your phone in?
Yes.
Okay. Can you send it to the court if I gave you an email?
Yes.
You know how to do that? And also, you might need to send a copy to them. All right. These are all non-payment of rent cases. Both of these.
There's a lot of issues, but we're slimming it down to non-payment of rent this morning.
Well, from plaintiff's position, what is plaintiff's claim in, I guess, either one of these cases?
Well, at this point, we are concentrating on rent. There's been only, how many months, 2 months paid? Only 2 months of rent paid.
So how much are you claiming is owed? How much do you have in this room here?
This includes water, because there's $1,900, more than $1,900 due for water bill for water that's left on. The balance is $15,899.39. $899.39. That gives her credit for the escrow. This with the court of $6,600. 2 payments of escrow have been made only.
She's claiming over 21,000 owing?
Yeah, she figures $22,499.39 is the balance. When I say she, I mean Miss Anderson.
And how much did you say?
66.
So much. Let's take a look.
Okay, I know that. I know that.
So what months is she claiming rent for?
All the months after, well, she has not paid anything since the first the 2 months, May and June. She owes the rent from July.
You're claiming for July?
Yes. August, September, October, November, and December. Not include, yes. Okay, don't. Into the court.
You paid what?
We know that.
Pay those months.
Where?
Talking about July and all that, I paid that.
Yeah, July and August have been paid. They're escrow. They're in escrow now. September, October, November, and December.
Just like council. So you're looking at 6 months, basically, right?
Yes, 6 months have not been paid to us. 2 months have been paid into the court. So this 4 months owed.
3,300. So, Ms. Lyman, I'm a bit confused because when we appeared here before, you had indicated that you were going to pay the rent into court escrow, and I don't have anything. I only have 2 months in escrow. How much did you pay in escrow this morning?
I paid that $22.70 that I said I was going to pay.
$22.70.
Yes.
What's this? That's still, but that's not, your monthly rent is 33.
Yes. Remember when I told you how I broke it down for the prorated amount? And that's where I came out to when we were here last time.
Okay, but if that paid, so here's my question. If I have in escrow July, we'll just call it July and August because those are the latest ones.
And I paid September this morning.
Okay. And then if that's, well, that's the 22.70.
Mm-hmm.
Yes, all right. So without going into even at this point, the difference between the two.
I'm only 2 months behind.
Okay, but where is the 2 months?
I don't have it right now. I was planning on paying at the end of the month.
I don't see how the 2270 pays at September either. And she's prorated it, but prorated, what does it mean? It's prorated. The entire amount is owed.
I understand that, Council. What did I just say? So you don't have October, November, or December at this point.
The rest I was thinking was planning to pay at the end of this month.
What do you mean?
Like to pay the rest off at the end of this month.
So basically 9,900.
No, it should only been about 7,000.
Why would it be 7,000? Your monthly rent is 3,300.
Yes, only these couple months. I thought it should have been 7,650. I thought that was all.
You know, we've got a copy
There's
of
6 months that's owed. Okay, I have 2 months in escrow. Right? So now I'm dealing with basically 4 months. You paid 2270. Again, I'm not going to get into necessarily why you got to that figure. I'll deal with that. I know what I have. But then when I look at October, November, and December, I have nothing.
Yes, because I didn't pay October, November, and then we're just getting to December.
Well, okay. So you're the two, at this point though, there's 9,900 that's owed at a minimum into court escrow. Right? What you say?
I suppose so, yes. Because I'm confused because I paid her May and I paid June when we first started.
The only thing I'm looking at right now is July through December. I'm looking at those 6 months. And if I'm looking at those 6 months, I have 2 and a partial.
Partial is in September.
Yeah. The $22.70 that you paid today. Basically a partial for September. Follow me?
Yes, I get what she's saying. I thought when I had mentioned the overpayment amount that I paid in June and the extra $300 and how much it would have been $533 to be prorated. That's how I came up with that $22.67. Because I only owe 3 months of rent, including December.
I don't know where this proration you have is coming from. Where you're taking monies off for September.
Because in May, I didn't get prorated at all in May.
Pardon?
I didn't get prorated at all in May when I moved.
When you moved in.
Yes,
You moved in on what day?
on the 5th.
But your lease started what day?
Which you started on.
On the 5th. And runs through what?
The 5th of next September. I don't remember the date.
I have a copy of the lease, Your Honor. It starts May 5, 2025. It ends May 4, 2027.
May 4th.
Of 2027. I have a copy of the, you've got it, okay.
So you follow that, ma'am?
Yes.
So there would not be a proration
How come?
because you would have 4 days in essence at the end of your lease. If your lease ended on the 30th or 31st of a month, I could see and get your argument about the 5 days because you didn't live there those first 5 days. But the way your lease runs, it runs from the 5th, but ends on the 4th of whatever month. So you get all your time. It's just not on the calendar month, basically.
I would remind the defendant that she's ignoring the water bill that's $1,900.
Why are you dealing with that right now? Did I ask you about it?
I brought it up because she's not,
Did you remind her of it?
just a reminder of it, yes.
Why?
Because she's not
I'm
talking.
trying to deal with something right now.
Okay, I'm sorry.
You follow that, Ms. Lyman?
Yes.
So give me a total of 66 plus 2270. 8,870. All right. Yes, ma'am.
I can pay the 533 today for the 5 days.
Say again.
The 533, I can pay that today for the 5 days.
So basically you can make September whole.
Yes.
All right. But what about the other 3 months and why aren't those paid into court as?
I got behind. A lot of family stuff had happened, so I had got behind. My plan was to pay those at the end of this month. Into this.
Are you still up?
It says it's still up. Because I paid a.
Hold on a second. That shouldn't happen. Are you sure?
Yeah.
We're still going. Say again?
No, because I was talking about the extra 200 that I paid in June and plus the 300 I was supposed to be getting back that 533. The $300 from the deposit.
For what?
When I overpaid in June, I paid $200 in June and then the $300 from the deposit that I was supposed to get back.
The 300 from the cleaning deposit? Or
No, it was for
the what?
moving in.
Your Honor, if I could explain, there was a security deposit. It was determined by the plaintiff that the security deposit was $300 too much based on the guidelines in this state of Michigan statutes. So she gave her a $300 credit, and it's shown on this ledger.
For June.
It's shown on the ledger for the total balance. It's from the balance. The balance. It's part of the number that
But what
is taken
month
into
did she
account.
get the credit for? Because
It's not for a particular month. It's just like on account. She's saying it's for a particular month. We're saying it's on account.
well, it's got to be for a particular month. When was the security paid?
May security. It was paid in May.
So if she overpaid the security, that means it's credited toward May rent. Gotta be.
All right, then we have credited it to her on the account, whether it's whatever month it's applied for. She's gotten that credit. It's shown on this ledger.
When did I get the credit? Because nobody told me. He was told that she was supposed to give me the $300 back. But
Say,
in June, I overpaid $200 as well.
I get what you're saying, that there was an overpayment in June. But how much did she pay in June? Just
30, she paid $3,300 in June.
3,300?
The rent, she paid her late fee.
Oh, late fee. Okay.
How much is the late fee?
At the time she paid,
How much is the late fee?
the late fee is $150, but I think she may have paid $250. I don't have those records with me. She just put it in my account automatically.
Council has a ledger sheet in front of you. Does that ledger sheet reflect that overpay?
It doesn't. It reflects a charge of $150 for a late fee.
But she said she paid 200 and something.
Yeah.
Okay.
She directly deposited the funds into my checking account. She didn't give me a pin. She put an extra $250 in the account for June. She directly deposited my account.
Okay, I don't care how it got there. Is the ledger sheet that council has, does it reflect that that payment was made?
No, because the letter sheet is just from July forward.
Why isn't there a ledger back to the beginning of her tenancy? Or if it's just from July forward, why doesn't it reflect? Does it give a credit at the beginning?
She's entitled to a credit of $100 for June.
How if I pay
How do I get $100 when that's not what Ms. Anderson just said?
She paid $250 for a late charge. Is that what? Okay, she should have paid $150. So,
she didn't give us.
okay, does the ledger that I have, that you have, counsel, does it reflect that credit?
no,
Why not?
my client compiled this from the date at which the date at which the rent was not paid. So
So there isn't a concurrent ledger that's kept?
Well, last time we were
Something
here,
that was made up afterwards?
go ahead and explain when you prepared this one.
I prepared this ledger I didn't know I was supposed to prepare it for the previous month. I just prepared it for July.
Why doesn't her account have a ledger? Why isn't there a ledger that reflects payments on this tenancy? What was the answer to that?
I just didn't prepare a ledger before. I didn't know I was supposed to prepare a ledger before the court escrow.
So how do I find out what she paid in May? How do I find out what she paid in May?
I can prepare a ledger. Sorry.
But where is that coming from? I don't.
Your bank account show the payments that you received?
Yes, my bank account shows it.
So, and so if that ledger starts out in July, this one that's been created, it doesn't show a credit.
For the $300 overpayment for the
June.
security deposit and the $100 overpayment for the, so we need.
But you
So I guess what I'm saying is, why come July, if that ledger's to be believed, do I not have a $400 credit, which means that for July, she should have only paid $1,900 or $2,900?
We have a $300 credit on the ledger. We just are missing the $100 credit.
Oh, that's
So we're missing the $100.
No. You have it at some point on that ledger, right? But if you created a ledger that accurately reflects this tenancy, that means her opening balance that she would have owed as of July 1 would have been $2,900.
Yeah, but yeah. So I can.
And so, counsel, the the amount you gave me of the 22,499.39, I think it is. Did that reflect $100?
No, I did not know about that. So it's 22,399.39 minus the escrow.
How much did she pay in security deposit?
The 525 plus the 750.
And where is that being held?
In my bank.
In what?
in my name.
Is it in a separate account?
Yeah, can I explain something?
No, answer my question.
Yeah, yes.
Or is it being held was the question?
Oh, Chase Bank.
In a separate account?
Since then I've moved.
Is it in a separate account? Has it been in a separate account from the beginning?
No, because I actually moved everything over to LMC.
I don't know where her security deposit is.
You said it's a Chase or it's been moved to?
I actually closed the Chase account down, and it's my LMC account.
What is LMC?
It's it's like Michigan credit. It's just I was getting charged too much.
Okay, just tell the judge where it is. What bank is it?
LMC.
What is LMC?
It's like Michigan.
Did you notify the tenant that that's where the security is being held?
No, because no, sir.
Is it in a separate account at this new institution?
No, sir.
It's just commingled with your account?
It's actually the savings account, so
Is it commingled with your savings account?
No, I have a separate savings account and I have a separate checking account.
I'll try the question again. Is it in a separate account that delineates it as a security?
No.
So it's in your savings or checking account?
Yes.
It's commingled with your funds?
Yeah, but I don't spend it.
It's commingled with your funds?
Yes.
Did you send that?
Yeah, I sent it.
Who'd you send it to?
I sent it to the district court.
Oh. They gotta pull it for me. That's all right. We'll get here.
Oh.
Well, tell Ann, please. So, Ms. Lyman, how much are you counterclaiming for?
Half
Half of what?
escrow. Amounts that I paid.
I'm sorry?
At least half of the amounts that I have paid in escrow.
All right, and on what basis are you claiming that money should be paid to you?
What do you mean by that?
Meaning, why should I give that to you?
Because I haven't been able to live peaceful.
So interference with your,
Peace.
all right. Any other reason?
Mentally. Emotionally, just the stress.
All right, but this is a contractual case, so some of those damages aren't there. But you're basically claiming an interference with quiet, useful enjoyment of the premises.
Yeah.
All right. And how much is the plaintiff claiming in additional water?
The water bill is 19, this is just for May 5th to December 8th, is 1915.80.
1915?
Yep, 80.
80?
Yep.
And the water bill, I had a payment plan. I had a plan figured out. And when I called, they said she called and took the water out my name, put it in hers and paid it. And then I sent the
Did
email
you
about
do that?
What happened was.
No. Did you do
Yes,
that?
because he said it would go to my tax bill. She didn't accept the payment plan by that date, the 13th of October, which she did not. I have the manager of the utility company said she did not do that. And so I came in personally and set it up and paid it with borrowed funds so that it wouldn't go.
I don't care where the funds came from. You paid it.
Yes, so it wouldn't go on my tax bill because that's what they do. They don't.
I understand what they do. I didn't ask all that.
I just was protecting myself.
So the water bill's been paid.
Yes, sir.
Do I have a receipt for the amount paid on the water bill?
Yes, sir.
When I talked to Landy.
There's been 3 bills.
We have one bill here.
We submitted everything to the court.
Well, we don't have it right now. It's one bill.
$13,1583.
Yes.
We'll just show that, Simon.
Okay. All right, it's okay. It's okay. Okay.
All right, Ms. Lyman, you saw that water bill?
Yes.
Okay. And that was the amount you were gonna set up a payment plan?
Yes, that's when I called to set up, they said like an hour and a half or an hour. She had called in, took the bill out of my name and put it in hers and paid it. And then when I emailed about it, she had said, oh, well, you can just pay me now. That's what she said.
Okay, but you're not disputing that that's a water bill you would have had to pay.
Yeah, that's what I would have had to pay.
You would have had to pay that 13, yeah, you would have had to pay it anyway. You were just gonna do it a different way with the township.
Yes.
Okay, all right. So you're not disputing the figure.
No, that's the amount that I got billed for. I had a payment plan worked out where I was just gonna pay it over time, not all in full at once.
Where's the email that says that it was going to go to your taxes if it wasn't paid or an arrangement not made?
I can get an email from the
I don't, you said there was one.
I have an email from the gentleman. I emailed it to the court. I CC'd the court. It's in the court record.
It doesn't immediately go on your taxes in any event.
They said.
It doesn't immediately go on your taxes. I know how it works.
I didn't work it. I didn't want to. Sorry.
She took it.
So why did you take it out of her name?
This is from Cindy Roberts.
Why did you take it out of her name?
Because I had to pay it on the 13th.
But you could have paid it and it stayed in her name. Why'd you take it out of her name?
I put it back in her name, but I just had to pay it.
That isn't an answer to my question. On the day you went in to pay it, you're telling me that you paid it because you were worried that it was going to go on your taxes.
That's what Cindy.
Okay, that's fine. It doesn't quite work that way, but that's fine. But then the question becomes, why'd you take the water bill out of her name?
Because I wanted to be responsible, so I wouldn't get behind.
But that's not what the lease says, does it?
It says it could be, the lease says it could be paid by me and she reimbursed me. You know, so I was just gonna give her the benefit.
Why was it put in her name in the first place?
I was giving her the option of being able.
Why was it put in her name in the first place?
They told me at the township that it could be put in her name if I wanted it.
Okay, so then it's put into her name. So then it comes down to this date. Why do you change the name on it?
On the 13th, they said if the water bill was due, it wasn't paid. I came at like 2:00 and they closed it
Why did you change the name?
because I wanted to be responsible for paying the water. I didn't want it to get behind again.
And so you couldn't be responsible without changing the name?
I could put it back to her name.
That's not what I said. You're telling me that you had to change the name so that you could be responsible for it.
So they could send me the bills and I can keep up with it and pay the water bill.
They would send you the bill anyway. You can always go online. You can look it up.
I just was concerned. That's all, sir.
But why was it important for you to change the name?
I thought I needed to be responsible for it. That's all. I just wanted to make sure I got the.
You're the homeowner.
Well, maybe I didn't know. I just did the best I could.
No, you did that to harass her. Because you could have paid that bill. At any given point, you can go right online and pay that bill.
Well, I thought
They don't care who's it's coming from. If that money is there, it's there.
the lease says that I can pay the water and she would reimburse me. I was just giving her an opportunity to put it in her name.
It was already in her name.
Not from the very beginning, it was in my name. It's different.
Was it in her name?
Not in May when she moved in. I put it in her.
That was the first month.
I let her.
In June, was it in her name?
No,
July,
no.
August,
I let her put it in August.
September,
Yes.
October.
According to recollection, I think I took it out of her name in October, so I think I had it in her name 2 months.
Oh, dear goodness, why? Why'd you do that?
I just wanted to,
That was a question.
I was just trying to get it paid, so. Sorry.
You would agree with me, Miss Anderson, that you could pay that bill without changing the name. You know, at the time you paid it, you didn't need to change the name, didn't you?
Do you want me to change it back, sir?
No, that's not what you knew at the time that you didn't have to change the name.
Did you know or did you not know that?
I didn't.
She said you didn't know that.
Okay, all right. Counselor, you gave me a number at the very beginning of 22,49939, which has been changed to 22,39939.
Yes.
As the total rent.
Yes, not counting escrow.
Right, not counting the escrow.
Right.
When you gave me 33 times 6, you gave me 1,900. So just so that I'm not double counting, I get for the 6 months of rent, I get 19,800.
Let's see, 8, 1, 3, 6, 19,800. Yeah, that's what.
Yeah, that's what I get for the 6
You don't have to
months.
point that out to me. I understand that. Okay. 19,800. That's correct for 6 months.
Okay, so what's our difference? When you gave me the 22, now 399, you gave me 22, basically 499. And then, but when I count the 6 month, I get 19,800. So I don't.
Okay, well, we also get 19,800 for 6 months, but we add to it the water bill of 1950, 80.
Gotcha. Okay.
And we get the court costs of 183.59. And we get late fees of $900.
Late fees of 900?
Yes, they're 150 per month.
Were late fees subtracted out for the payments made into court escrow?
She was late every time it was paid.
Why can't I just get an answer to my question?
No, they were not taken into account in the money she paid to the escrow. She paid $3,300 twice.
So I want to be clear on this, Ms. Anderson, because Ms. Lyman is claiming, and throughout the course of this case, and counsel, you haven't been here while it's been going on. She's claiming interference with her possessory by you.
No, sir.
On the day that Ms. Lyman is claiming, before I go back and look at this tape, did you send a gentleman to the premises? Make sure you give me a correct answer.
That was your question? Okay.
Did I send a gentleman to the house? No. She said I was in the car.
You have also, to this court, indicated you were not in the car in front of the house. Is that correct?
Sitting in the car in front of the house? No, I drove by one time. Just to check on the house. I've driven by one time in 4 months. 4 months I've driven by one time.
It was not that. He's not asking about that.
No, I was not in front of the house waiting for anything.
Do you know anything about the gentleman that came to the house and came around the back of the premises as Ms. Lyman has indicated?
No.
Ms. Lyman, just to be clear, what date was that? November 10th.
At like 9 in the morning.
She has not.
She is not. She's asking.
It was like the same outfit like on today. It was like a tannish, little pinkish color that you.
Tannish.
Like the hijab.
Okay. Give her Ann's email and have her send it.
Because it wasn't the first time that somebody had walked around the house. She sent, I believe, her contractor before it all.
A lot of Muslim women in the neighborhood. A lot of women wear hijabs in our neighborhood.
And what's your argument in terms of the interference with her possessory interest?
There's been no facts presented other than this person who walked to the back of their house about interference with her possessory interests.
Okay, so that, and I hear you, counsel, but can I just say that? And again, you weren't here when that other case, and when I was coming back to you by decision, actually, she's put forth other claims of where your client has gone to the house. This one that she put forth today is one that wasn't included in that.
Well, I know that you were not again. What the heck? I'm sorry.
Was at the house was when he was court ordered. I haven't been at the house since. I don't go to the house.
Oh, okay, all right. There was a court, I know that there was a court-ordered inspection.
Yes.
And she was.
Because there had been problems with coming to the premises and then claims that she wasn't able to get in.
Right, you were there at the inspection, right?
Yes.
Okay, she was there at the inspection.
Correct.
Me and
Okay.
I've been specs,
You've not been there other than,
driving by.
you already talked about driving by.
Yeah, just to make sure the house is still there.
You've not been on the premises.
No.
Except for
Have
that
you
inspection.
sent others on the premises?
No.
You've not authorized anybody to be on the premises, Ms. Anderson?
No, I don't even know if it's still there. I drive by every now and again to make sure it's still there. But I don't.
Okay, you already said that. Okay.
I'm gonna say, counsel, that, and again, you're at a slight disadvantage that doesn't quite fit with what's been presented to the court previously. So, all right, you sent that video.
Yes, I said.
All right, so what Ann has a,
She said she'll let us know when she receives it.
all right, so what I'm gonna do is I'm gonna stand in recess, and counsel, I think we have your email.
I don't think so.
No, we don't.
I'll give this lady.
So
Yeah.
why don't you give it to her? And then what I'll do is I'm going to take a recess. When it comes through to us, we will send it right to you, counsel.
I'd appreciate that.
Because that way I know it will go to your phone because you've been answering it all. No, I'm just kidding. Yeah, all right.
Spam calls that are spam.
No, it's okay. I understand. Our court's going to stand in recess. Everybody can be.
Somebody. Thank you.
Your Honor.
Thank you very much. Ma'am, what is your name?
I'm the interpreter for defendant Vladimir Hameduk.
At 10 o'clock.
Is the defendant here?
You never check in with me. I don't know, the state prosecutor's file. He didn't
What's
check
the
in.
name on that one?
John, tell me the name.
10 o'clock, Vladimir Hameduk.
The attorney is in the breakout room with the prosecutor.
Oh, okay. Well, so we have the interpreter here. Is it Arabic, ma'am, or what?
No, it's Ukrainian.
Ukrainian, okay. Okay. So
Defendant's just not here.
is the defendant not here?
I'm assuming he's with the attorney. It's a retained attorney.
And the retained lawyer is where? By Zoom or in?
He's by Zoom in a breakout room with the prosecutor.
All right, well, we need to tell the defense lawyer that the interpreter is in the courtroom. Is that a felony?
No, it's a misdemeanor. Drove while license suspended.
Yeah, so we need to set them up. Can you go in and pull the lawyer out and bring him in here, please? I mean, whatever's easier. I just want to explain to him that the interpreter's rights.
He's the one that requested the interpreter, but they don't need it while he's in with the prosecutor.
No, I know that.
So I just thought when he comes out, I'll tell him and put him in a breakout room if they need it.
Okay. Yeah, so we're
I got it, Judge. I'll handle it when he comes out.
okay. Ma'am, just have a seat. We're going to set you up. Okay. Thank you. I don't have anything else ready, do we, Lisa?
Nope, nothing on Zoom.
Okay. Thanks. Stay seated, ma'am. You're good. Okay.
Judge, talk to you, okay?
No, I'm just,
20 right in March,
I had,
right?
yes,
If you plead to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 90 days jail, costs are all those 0 points. It won't get reported. Do you understand that?
yes,
If you plead to 5 over, that's a 0 point violation. Limited access is, but that will go on your record, but 0 points. Do you understand that?
yes,
All right. Did you sign, read, and understand an advice of rights form here today?
yes,
If you plead guilty to allowing an unlicensed driver to drive, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
yes,
To the charge allowing an unlicensed, I'm sorry, by the way, I have to tell you again, you have the right to an attorney. If you want one, I'll give you one. Do you want one?
No.
I'm sorry.
no,
To the charge allowing an unlicensed driver to drive, how do you plead?
guilty,
On the 4th of November of 25 at 4 p.m. were you on I-75 northbound or Gibraltar Road in Brownstown and operating a 2025 Jeep?
yes,
Did you allow somebody to drive that was unlicensed, and was that you?
yes,
Are you on probation?
no,
Parole?
no,
Anybody forced you to plead guilty?
no,
To the charge 5 over, 75 and 70, responsible or not responsible?
responsible,
I'll accept those pleas. That is allowing an unlicensed driver to drive 75 and a 70, dismiss the no license as well as the 91, 93 and a 7. Got to slow down your record. Geez, you're killing trees here. You got warrants all over the place. Why aren't you taking care of those?
I thought they was taken care of because I just got my license back probably about like 4 years ago. And
Well, you were in suspension and you got warrants out of Dearborn, 2 of them, Taylor, Clinton, McRoseville, Grosse Pointe Farms, 36th District, Warren, 36th District, 43rd District in Ferndale, and the 10th District in Battle Creek.
yeah, I'm just trying to get everything together. I actually pay $800 a week in child support. So
Then you're making good money. How much do you make?
I make $38 an hour.
Where do you work?
I work at Chrysler.
There's no excuse for you not taking care of these. You know that, right?
Yes, I do.
Anything else you want to tell me before I sentence you?
No, I just since I have got my license back, I've been trying to keep up with them because I do commute from state to state every day to drive to work.
Listen, you got to use your head. You're going to lose that job. You keep conducting yourself like this. I'm just telling you. You can't do this. 100 fines, 225 costs, 75 victims' rights, $50 justice assessment, 450 or 90 days, and 170 on the speed. Your total 620. Can you pay that now?
No.
How much can you pay today?
I actually don't get paid till tomorrow.
How much can you pay tomorrow? You pay all this?
Yes.
All of it?
Yes.
You sure?
Yes.
I'll
Said
pay
670, right?
620.
Yes.
The A file's 450. So you pay that. I'll just give you until the 11th, which is Thursday. Okay.
Okay.
And then you pay the other one by Thursday too. Listen, use your brains. You seem like a nice guy. Save your money.
Yeah.
You're spending it too much or something, aren't you?
Not really. I was really I was off of work for a year, so I went to 23,000 in parents for child support. That's why my benefit's so high right now.
I see. Okay. All right. Well, best of luck. Have a nice Christmas. If you need more time, something comes up between now and Thursday, call the court. We'll go on Zoom. I'll be glad to give you an extension. Okay.
Okay. Thank you.
Good luck. Timothy Gallagher, 25M6245A, B and C. Your name, sir?
Timothy Gallagher.
So you guys talked about an adjournment until January 13, right?
Yes.
So you get your license. What time is that, Lisa?
It'll be 9:30 with Judge Hessen.
That'll be 9:30 a.m. You're gonna be in front of Judge Hessen. You can go down the hall and get your notice, okay?
Okay.
Nice Christmas. Good luck. Secreto, Brandon Lee Secreto, 25B149110.
Is that the arraignment?
Yeah, I don't know who. I think
Brownstown?
Yeah. I don't know I don't know who the defendant was or defense lawyer. Mr. Shemke, it must be. Okay. Mr. Shemke, your appearance.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time, extensive matter being heard via Zoom.
Those look like swimming goggles or something, huh, Mr. Shemke?
No, just regular glasses, Judge.
Okay. Mr. Secreto, how you doing? Why don't you stand up a little bit? Are you okay?
No, sir. I have bulging disc in my back, sir.
Your name?
What is it?
Your name. What's your name?
Brandon Lee Secreto.
And detective, your name?
Detective Claff, Brownstown Township Police Department.
Does he stand me a waveform rating?
Yes, Your Honor.
He doesn't like to show up in court.
I didn't. Your Honor.
I'll have an opportunity to speak on your behalf, sir. Just wait.
Go ahead, Mr. Shemke.
Your Honor, my client's currently 40 years old. He has two twin children, ages 5 months. He was actually working as of 6 days ago, but he's currently on medical for an injury that he suffered. He was delivering for a local business. He currently lives in Brownstown alone. There might be some miscommunication on this trespassing, but he understands that while this case is pending, he cannot go back to that Brownstown address. He does have alternative lodging at the Lincoln Park address with his uncle. Judge, I don't believe this was any malicious intent. He indicated that he had no knowledge of this court date, but will absolutely appear at any and all future court dates. We'd humbly respect any leniency when determining an appropriate bond. He's not on probation or parole, nor does he have any pending cases. Thank you.
Where do you live?
I live at 1866 Monty and Lincoln Park, Your Honor. But Your Honor, the mailing address that you guys have for me is address.
Slow down.
Yes, sir.
Can you give me a bond sheet? Wait a minute. How long ago did you live on Cornell?
I've been living there, sir. It's just recently that
Slow down. I have a feeling you're going to start dancing. I have a feeling you're going to. I didn't ask you that. I don't know what recently means. I don't know what that means. Does that mean you were there yesterday, the day before that? I don't know what that means.
I lived there for.
I didn't ask you how long you lived there. I asked you how long you lived there until. Look at me, Mr. Secreto. Don't talk to him.
Yes, Your Honor. Yes, Your Honor. I'm just in a lot of pain right now, sir.
Yeah, okay. Well, you know what? You should have shown up in court.
I didn't know I had a court date, sir. My mailing address is that address, and nobody let me know that I even had a court date, sir. Your Honor, it was probably about.
Whoa. You're gonna agitate me really quick here. You know that?
I'm sorry,
I
Your
want
Honor.
you to answer my question. Look me in the eye. When did you stop residing at 20095 Cornell in Brownstown?
3 weeks ago, Your Honor.
Well, then I don't know why you didn't receive your mail. We sent these to you in November. You got one in October, scheduling it for November 20, and we set another one for December 3rd. Don't tell me this stuff.
Yeah, I'm wrong about my dates, then, Your Honor. I've been going through. Whenever she filed the petition with you guys, it was about a week before that. Your Honor.
Did they give you the citation in hand, sir?
No, Your Honor. I haven't received nothing. I was just told by an officer not to come back there. That was it. The last time I was there, Your Honor. I was told not to come back or I'd go to jail.
Sir Grimm didn't give you a copy of the citation on October 29th?
Well, no, I haven't received nothing. They asked me to leave.
He says he checked the box saying he gave it to you.
No, Your Honor. I haven't received no paperwork from nobody. I was told by an officer not to come back. He told me to get in my car and leave. I did what the officer told me. They followed me to Telegraph. They followed me to Sibley, and then they let loose on me. And the officer told me when I got in my car, he said he understands it's something that I had to deal with the courts with, and he said do not come back or he would be forced to take him to jail, Your Honor.
Boy, you got quite a record.
Yes, Your Honor. I changed my life a lot, though, Your Honor. I become a truck driver. I'm trying to do my best. I just had twins, me and my fiance. So a lot of my time and all my money really goes to them right now.
He's still got quite a record.
Yes, Your Honor. I made a lot of horrible mistakes as a kid. And
hang on a second, slow down. Detective, can you help me out here? Was he alleged to be trespassing at his own address?
Your Honor, I have an initial report here.
Where were you picked up, Mr. Secreto, while he's doing that?
In my car, Your Honor.
Driving?
I was parked, yes.
Where?
I was parked. Basically the auto shop on Sibley. Sibley by Telegraph and Sibley, basically right next to the McDonald's and all of that right there.
Why were you there?
I was sleeping in my car, Your Honor. My car has been messing up on me. The guy at the auto shop is gonna help me with parts. And I basically just fell asleep in my car. An officer approached me and asked what I was doing. I told him. They talked to the owner of the shop and he verified and told them that it was okay that my car stayed there. My whole front end, my upper and lower ball bearings are really messed up on the car.
What is your address now?
1866 Monty. That's my uncle's address, sir.
Montie?
Yes, Your Honor.
And that's in?
Lincoln Park. It's the only address I really have right now, Your Honor. I've been
Hang on.
Yes, Your Honor.
Who are you living with there?
It's my uncle, James Dandy.
All right, Credo, slow down. Detective, tell me what you're reading in that report.
Your Honor, it looks to me that he went to visit his kids at this location, 20095 Cornell. Female caller made a complaint about him being there. Officers went out and confronted him, advised him on trespassing, and he went about his way. We explained to the caller about the steps to obtain the PPO order through the court downtown. As far as addresses go, the way the report reads, I guess I don't know if he was where he was living at that time.
Somehow license everything.
Mr. Secreto,
Yes, Your Honor.
I should give you a cash bond. I'm not going to. You're not to go near 20095 Cornell in Brownstown. No contact with prosecution witnesses. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. I'll give you a personal bond of $500, but if you don't show up again and you end up in front of me, you better have a lot of money with you. You understand what I'm telling you?
Yes, Your Honor. I won't miss another one, I promise, Your Honor.
What date are we going to do on this? Oh, it's probably on the front here. We're going to do December 17th at 10 a.m.
Yes, Your Honor.
So you're going to be here next Wednesday at 10 o'clock in the morning, okay?
Yes, Your Honor.
Good luck to you.
Thank you.
George Patrick, thanks, Detective. Thanks, Mr. Sheriff. George Patrick Merlino Jr., thank you. 25T724-965. Who's on this one?
That's an arraignment. The defendant's in custody.
Your name, sir?
George Patrick Merlino Jr.
So has he been set up with a lawyer yet, Lisa?
Today's the arraignment pre-trial. We were just notified that he was in custody. He hasn't been arraigned.
Okay, so we didn't have him with a lawyer then at all, right? No lawyer entered an appearance and.
Nope.
So I got to set him up with a lawyer. Are you in custody on this case, sir?
I don't even know what the case is, sir.
Why are you in jail right now?
For a case, but not this case.
He's got a felony that he's serving 12 months on.
I shall plead by, sorry, sir, I shall plead by mail. Is this a Woodhaven courtroom? I shall plead by mail in there, admitting guilty to the driving unsuspended. I never got arraigned on it, though. I caught COVID, missed a court date.
I think we just issued a warrant on November 12th and we found out you were in the Wayne County Jail, so we had you writted out. Who's our lawyer today, Graziani?
Yes.
Well, this is what, a Treppy? Is this a state case?
Yes, it is.
I got locked up October 22nd, sir.
Okay, this is a state case. We got to set you up with somebody. Why don't you keep them there, Lisa? And John, you
Can I find out what the charge is? What's
It's
the charge?
assault or assault and battery. Let me get you a lawyer right now, okay? We'll get you a lawyer that will zoom in with you. All right? Just be patient.
All right.
Good luck. Is Ferris Arslan out there?
No, but the attorney's here.
All right, bring her in, please. Ferris Arslan, 25W727583. All right.
Mr. Arslan.
Ms. Tucker Davis, your name?
May it please the Sonoma Court, Don Tucker Davis, P59229, representing Mr. Ferris Arslan.
I made you wait long enough. I'm going to go ahead and issue a warrant, forfeit his bond. I don't know where he is. He knew better. He should have showed up. 25,000, 10%. Okay. $25,000, 10% warrant issue bond to be forfeited. This was scheduled, by the way, for 9:45. You've been patient. It's now 11:30. So we have your phone number here somewhere, right? On one of these files, I'm sure. So if he does manage to show up, we will call you, okay?
I appreciate that. Thank you, Your Honor.
Thank you. Have a good day. Mr. Perlman, what do you have, sir?
Good morning, Judge. I have a Mr. Kamaduk, and there's a Ukrainian translator also on Zoom, I believe.
Okay. People against Vladimir Kamaduk.
Yes.
25M601395 A and B. Can I have the translator state her name, please?
My name is Alla Abbott, ALLABBOTT.
And you are, okay, I don't know what happened there. We lost you and you're muted, so you have to start your video again, Ms. Abbott. Ms. Abbott, I don't know what happened to you.
Just a second.
All right, there you go. Now you have to unmute. Bottom left-hand corner of your screen, you want to unmute. All right, there. Now you muted again. Okay, that's good. That's good. Raise your right. You keep muting again. You got to unmute. No, you got to unmute. There you go. There you go. Perfect. Raise your right hand. You solemnly swear or affirm that the information that you'll make a true and accurate translation between the court and the defendant.
Yes, I swear.
And what language do you speak?
Ukrainian.
And the defendant speaks Ukrainian, correct?
Correct.
And are you licensed by the state or certified by the state? It just
I'm a qualified court interpreter with Michigan State
right.
of Michigan.
All right. So you're going to make a true and accurate translation. We're going to go slow. Mr. Perlman, state your appearance, please.
Yes, good morning, Jeff Perlman, on behalf of Mr. Kamaduk.
Таким образом, адвокат представил себя, и він представляє ваші інтереси, пану Владимир Хамедук.
Sir, your name, please.
Владимир, і назовіть, будь ласка, ваше ім'я та прізвище.
Вы можете говорить и по-русски ко мне. Я одинаково, что по-русски, что по-украински.
Добре.
Камедюк Владимир.
Владимир Камедук.
All right. For purposes of arraignment, Mr. Perlman, on the driving on a suspended.
My client will enter not guilty, and wait for more reading of the information.
Таким образом, сегодня оглашается ваше звинувачення, що ви керували транспортним засобом без діючих водійських прав. Що ми робимо сьогодні?
Now, your client is going to plead responsible to following too closely with the driving on a suspended to be dismissed. True?
Correct.
Правда, что ваш клиент будет сегодня признавать свою вину, что он ехал слишком близко к другому транспортному средству, звинувачення таке, що ви керували транспортним засобом без діючих водійських прав, буде закрито.
Is that what you want to do, Mr. Kamaduk?
Это то, что вы хотите сегодня сделать, господин Камедук?
Да.
Yes.
To the charge following too closely, how do you plead? Responsible or not responsible?
Таким образом, то, что вы ехали слишком близко, как вы будете отповедать? Вы ответственны чи ні? Винны чи ні?
Да. Okay.
Yes, I'm responsible. Yes, I'm responsible.
Your plea is accepted.
Таким образом, ваша відповідь прийнята судом.
The driving unsuspended is dismissed.
Таким образом, ваше звинувачення в тому, що ви керували транспортним засобом без діючих водійських прав, зачинено, закрито, сміщено.
And I'm ready for sentencing.
И я готов, чтобы вынести решение.
Окей, я жду.
Anything you like to say, Mr. Perlman?
Вы хотите что-либо сказать? Адвокат.
Yes, thank you for the court. And I'm just asked that my client be able to pay the fine today and have this matter resolved.
Я только хочу запытать своего клиента, может ли он сегодня оплатить, чтобы эта справа была закрыта.
Anything you would like to say, Mr. Kamaduk?
Пан Камедук, вы что-то хотите сказать суду?
Ну, что я могу сказать? Я только не понял одного, что у меня в тикете написан, офицер сказал, что я ехал, у меня дистанция до предыдущего автомобиля была 500 фит. Я не понимаю тогда, сколько фит должна быть дистанция между автомобилями, если по правилам 50 фит.
So the only thing I don't understand, because the officer made a note in my ticket that the distance between my vehicle and the vehicle that was ahead of me was 500 feet. And so what is the minimum distance supposed to be if it's considered to be too close?
I don't know how fast he was traveling. All I know is he pled responsible. So I can't quite answer that without knowing the speed, and I don't see any notations that he was 500 feet away.
Треба знать, с какой скоростью, как швидко вы ехали. И я не могу ответить на это питание, на этот вопрос, потому что не знаю, с какой скоростью вы ехали.
Interpreter fees are $160 an hour. I'm not going to charge you that. I'm going to charge you $200 in fines and $125 in interpreter fees, 3 1/4.
Could you repeat the fines and costs?
$100 in fines, $125 in interpreter fees.
Yes.
They charge $160 an hour according to this paper, but I'm not going to charge you all of that, okay? So it's 3 1/4.
Окей, судья говорит, что треба будет заплатить за перекладача, за переводчика $125, но это по минимуму, потому что так за переводчика суд оплачивает гораздо больше, 160 час.
Okay.
So tell them to go online and pay the 3 1/4 today, then.
И там какие-то еще будут штрафы, но если сегодня вы можете оплатить по онлайн, можно оплатить онлайн, зайти на сайт суда.
Okay? You all set?
Yeah, okay.
Have a good day.
Good luck. Thanks, Mr. Perlman.
Thank you.
Thanks so much, Ms. Abbott. And good luck to you, sir.
Thank
you. All right.
Спасибо.
Tricia Lynn Ely, 25T711-513.
Good morning, Judge and staff. John Graziani, appearing on behalf of Tricia Ely.
Ma'am, your name?
Tricia Ely.
So this can be a plea as charged under 7411, right?
Correct, Judge.
Ma'am, if you plead guilty here, this is punishable by up to a year. I'll take it under section 7411 of the Michigan Compiled Laws, section 333.7411, meaning that if you're compliant at the end of the specified period of time that I set, the case will be dismissed on motion of the prosecutor. Do you understand that?
I do.
In the meantime,
If I may, I just want to explain to you too that Miss Ely had, even though we'll go into the probation and the sentencing, Miss Ely had purchased this item in this, that we have right now in Washtenaw County, which I consider another country, and it was legal in Washtenaw County.
but she possessed it in Wayne.
That is correct, Judge. I just simply want to mention that for.
Hang on, man.
That's nothing
Hang
else.
on. So I want you to understand, they're just charging you with possession. I don't know anything about it being legal in Washtenaw County. It's mushrooms, right? And you are charged with that, and you could get 1 year if you plead guilty here. I'll take this under section 7411. I'll place you on probation. I'll set terms and conditions. If you're compliant at the end of the period that I set, the case will be dismissed. Do you understand that?
I understand. Will it go on my record?
Listen to what I'm going to tell you here. Right now, yes, it's going on your record under 7411. At the end of this period of time, it's going to be dismissed, but it's only going to be available to police officers, courts, probation officers. It will show that the charge to probation officers, police, and judges that you pled guilty, it was taken under 7411 and then dismissed because you were compliant with your probation. That's what it will show. Do you understand that? You seem confused.
Judge, I explained it. Please don't. Judge, I explained it to her. I explained exactly what you're stating. She's been going through a lot, Judge. She's been.
Okay, well.
I don't know if I'm going to plead guilty.
Well, then don't plead guilty. This is the United States of America. I mean, you don't have to plead guilty if you don't want to. You might have a hard time beating the charge. I don't know if you will or not. That's for you to find out from your lawyer. But this way, you're at least keeping the case off your record if you're compliant with probation. Period. If you don't want to do that, you don't have to do that.
What's the period of time for that?
I don't know. I don't know one thing about you. They're recommending 6 months reporting probation. Alcohol assessment, treatment if necessary, and any other terms, conditions, fines assessed by court. I don't know anything about you, so I can't answer that question for you. That's why I'm ordering a pre-sentence report to find out more about you, screening and assessment.
Okay.
Okay, if you're nervous about this, you want a week to think about it.
I'm a color guard mom. Others knew that I want to be able to participate and be the PTO and do the things for my daughter this year. That's all.
Okay, but I'm just telling you, if you want time to think about this, I'll be happy to adjourn this and let you think about it some more. You don't have to take this today.
Judge, I have a number of matters for the 23rd of December, and if she'd like to think about it.
Yeah, well, nobody has a problem with that.
Okay.
You want to think about it? Okay, we'll have you back on the 23rd then, okay?
Judge, thank you so much.
So what, no problem. So we'll adjourn this to the 23rd. Obviously, you'll have to go in and get another, we'll keep this one in the file, counsel, but you'll have to go in and have it rewritten up, okay? Just
Good, Judge, thank you.
what time you want to do this, Lisa?
9:15.
At 9:15, okay, ma'am?
Lisa.
Okay, do you understand everything?
Yes, sir.
All right, relax, take a deep breath. Go down the hall, get your notice, and then we'll see you the 23rd. Good luck.
Thank you.
Judge, I'm going to talk with Mr. Merlino right now.
Okay. That Corporal Shapaniak, do you have something in here or you just?
Your Honor, I was just waiting on Merlino and Ely.
And he just said he's going to talk to Merlino. Yeah, so Ely, what did we do? Didn't I take care of that one?
That was.
That's the one we just adjourned.
Okay, sorry.
Yeah, so all we got is Merlino left and he just went to talk to Merlino, okay?
Thank you, sir.
Thank you. Justin Paul Riney, 25E149654, default judgment. Defendant failed to appear yesterday. That was for a department. Yeah, Arroyo. This is Ileana Elizabeth Arroyo Geigel, 25B, 148-667B. Then failed to appear yesterday, 282 cash for surety. That was for a contempt charge. People against Dow. Bailey Leanne Dow, 25B, 148-814B, 282 cash for surety. Then failed to appear yesterday. Decovane Andre Foster Williams, 25M, 550234, 213 cash or surety. Warrant issue. People against Decovane Andre Foster Williams, 25W839-411, 213 cash or surety. Warrant issue. Caprice Love Hartley, 25F2443808, 255 cash or surety. Christian Cornelius Lyles Weems, 25E 149-111, 282 cash or surety. Austin James Maderi, 25F2444-288, 255 cash or surety. Tricia Lynn Smith, 25T646097A, 213 cash or surety. Katiana Lamar Thornton, 25E148-878, 255 cash or surety for failure to appear yesterday. Treasurer Rosemarie Welch, 25W839-161, 273 cash or surety. Zachariah Gonzalez, Oscar Arnaldo, Zachariah Gonzalez, 25T646244B, 69 cash or surety. Warrant issue. Raymonte Ronald Young, 25B148-921B, 213 cash or surety. Michael Leroy Barnes, 25W839-225C, 285 cash or surety. Warrant to issue. Michael Leroy Barnes, 24W836-758B, 282 cash or surety. And also on a C file, 213 cash or surety. Algene C. Cole Robinson, 25W839-509, 213 cash or surety. Amar Bir Singh, 25M576379B, 309 cash or surety. Agmar Singh, 25M757637-9A, 213 cash surety. Warrant to issue. Lynn Smith, 25T646097B, 287 cash surety. Desmond Copeland Denham, 24W837-002, 213 cash surety. Off for failure to appear yesterday. Joseph William Wynn II, 25B147-843B. Warrant to issue, bond to be forfeited, 483 cash or surety. Well, actually, apply bond to payment of fines costs. Apply bond to payment of fines costs. Defendant failed to appear in close case. You got a bond of 483 cash. Roper, Alasia Deshaun Roper, 25B256867, warrant issue. Defendant failed to appear. 530 cash or surety. And finally, Isaac Julian DeJesus Geisel, 24.835-6467, warrant to issue 555 cash or surety. Okay, that's it. Counsel, you got one with Merlino. Is that done?
This is file 252254FY. Ms. Allen is charged with assault with a dangerous weapon, also known as felonious assault. Which allegedly occurred on November the 5th with her spouse, I think. Ms. Ives, what's the status here?
Your Honor, at this time, my client would like to proceed forward to the exam.
All right. When I talked to you last, Miss Allen, you were about half a step above homeless. Where are you staying now?
I'm now in Sturgis with Mr. Brown.
At the Mechanic Street address? All right. That prelim will be 12/16 at 1 o'clock. Your bond is continued. You're not to have any contact with Bell Ghost. And the screwy thing is, when you got arrested, they had you and Bell in the same cell, sitting right next to each other, and you had no contact provision. So I let you out of jail, but you've held up your end of the deal and you've appeared for everything. So your next hearing date is next Tuesday at 1 o'clock.
Okay.
All right, you're good to go.
Thank you, Your Honor. What's your address?
Mandy, you do owe a bunch of money, as you know, $785 worth of a bunch of tickets.
I can start making payments on that on the 16th.
All right, I'm going to ask you that because you've been blowing these off for a while, and we'll talk about whether you made a payment on the 16th or not.
Okay.
Kate and Bathgate.
Mandy, don't forget you got court on Friday morning, 8:30. Your Honor, do you think we could do Mr. Sanford Haley before I go to see Judge Patterson?
She showed up late and has demands on what order.
Yes, she is. That's true. I thought that was your case. That's her style. Let's do Sanford Haley.
I'm sorry.
I thought Bathgate was yours, and I was going to do your two cases. I just got them out of order. You want to keep Judge Patterson waiting. Good morning, sir. Are you Sanford Dean Haley?
Yes, sir.
Again, we've met, but you're charged with assault with intent to commit great bodily harm, domestic violence, and interfering with the crime report. Those allegedly occurred on June 16th of 2025, and the complaining witness is Crystal Lynn Allen. What's the status here, Ms. Ives?
Your Honor, at this time, my client is asking for his exam.
Is there a plea offer, Mr. O'Bear?
There was a plea offer made of count 1, assault by strangulation. The other counts of habitual would be dismissed. The preliminary exam is held. That offer would be revoked and we continue to trial in circuit court without any further negotiations on the case. If Mr. Haley would waive, that offer would remain open, and so would the ability to negotiate.
All right, so you got the word. We'll set this for prelim. We're going to be very busy next Tuesday afternoon. That will be December 16th at 1 o'clock. Mr. Haley, I don't see that you owe me any money. Do you have any questions? All right, we're going to presumably be set for a prelim next week. If that is a prelim, any plea offer is revoked. Please up Ms. Ives. Let's take care of Mr. Truckee, and he can get on with his client, and then we'll deal with All right, are you Caleb Stainer?
Yes, sir.
File number is 252434. You're charged with home invasion, 2nd degree, aggravated stalking, interfering with a crime report, and domestic assault. You're on bond on an earlier domestic violence charge, which is filed 252330. That's set for a final pretrial January 22nd of 2026. They set the bond quite high, $30,000 cash or surety, and you did post it. Mr. Truckee, what's the status here?
It's not resolved today. There is a plea offer. Mr. Robert's indicated he'll keep open until Friday. And Mr. Stainer's going to talk that over with some family and consider it and hope to resolve the case prior to Tuesday.
Is there an effort to try to resolve both cases?
Yes.
Mr. O'Bear, what is the plea offer?
The plea offer would be to plead to DV and illegal entry in the file that's up to date, and DV in file 252330 SM. The felony charges will be dismissed.
All right, for the time being, we'll set for prelim for December 16th at 1 o'clock. Plea offer remains open for the time being. All right, thank you. You're good to go. Now, wait a minute. You also got an unpaid booking fee, but I'm not worried about that. Your next court appearance will be next Tuesday at 1 o'clock.
Thank you, Your Honor. Thank you.
All right, Casey, I think we've cleared the decks for everybody but you.
And he did fill out an advice of rights as well.
Thank you. This is file 252389 FY. Are you Caden Matthew Bathgate?
Yes, Your Honor.
Mr. Bathgate, you're charged with resisting obstructing a police officer. Let's go back and look at your complaint. There it is. The complaint alleges that on November 1st, that you did resist, batter, wound, obstruct, oppose, or endanger Courtney Taylor of the Three Rivers Police Department. That is a felony punishable by up to 2 years imprisonment and a fine of up to $2,000. It's alleged that this happened, as I said, on November 1st on South Main Street. Mr. O'Bear, what's the circumstance here?
The offer is for the defendant to plead to attempt to harm.
Attempt article means attempting to resist or obstruct a police officer. the charge of resisting obstructing is a felony. It didn't used to be, but it is now. If you make something an attempt, it makes it half of what the original charge is. And an attempted resisting obstructing becomes a misdemeanor. Attempted resisting obstructing, it's punishable by up to a year in jail and a fine of up to $1,000. Do you understand?
Yes, Your Honor.
Are you going to plead to that misdemeanor charge?
Yes, Your Honor.
And you signed an advice of rights acknowledging that you're waiving your right to have a trial and everything that goes with that. You understand?
Yes, Your Honor.
All right, I read the affidavit in this case. This is at night. They're looking for a stolen car. They pull up at Chuck's Body Shop. There was a car with its hood open. And you and 4 or 5 other guys are in this car. They'll take off. And so when the officer from 3 Rivers told you to, hey, stop, did you take off and run away?
Yes, Your Honor, but I didn't hear them say stop.
All right, how far did you get?
Cross the railroads.
And then you got stopped by another 3 Rivers officer?
Yep.
All right, so I'm gonna need some context here, and so I'm probably gonna need to set it for sentencing. So there's this car, which may or may not be stolen. You guys are all at Chuck's Body Shop with the hood open. Is the only person that got caught you?
No, Your Honor.
All right, who else got caught?
Everybody
Rest are
else.
juveniles.
Oh, others. And you're the only one over 17,
Yes, Your Honor.
over 18?
And he is just 18, so at the time of sentencing, we're going to be requesting HIDA consideration.
I don't have any objection to it being a higher probation.
Can I just do it now?
If the court's comfortable doing that, I have no objection to that.
All right. Tell me about this car. What was the deal with this?
So I was in Battle Creek with my girlfriend, ex-girlfriend at the time, and her family, and for hanging out and stuff. And my friend calls me. He says, "I'm coming to pick you up." I was like, "Okay." I didn't know the car was stolen until we got to 3 Rivers, and he said, "If you see the cops and stuff, run. Car's stolen."
And then, all right, so did the car conk out or something? And then you guys lift the hood and try to figure out what to do with it.
Yep.
What kind of car was it?
A Chevy. I'm not even sure. Chevy something.
All right, so the cops pull up and everybody bails.
Yep.
All right. Were you guys drinking?
I wasn't.
The other kids were?
Yep.
Are you on probation or parole for anything now?
No.
What do you do, sir? Do you work somewhere?
I have a job interview later today.
Where's that?
El Camino in 3 Rivers.
And Your Honor, for purposes of sentencing, Mr. Bathgate he's living with his mother. She works at Pivotal. He's started to engage in pretty significant therapy and mental health assessments to try to start addressing any and all behavioral concerns and or alcohol concerns that are present. This was a wake-up call for him. And mostly that's why we're seeking the height of protection and a term of probation. I'm sure he would be willing to sign releases for his probation officer to share all of his ongoing treatment with his officer.
HIDA stands for Homes Youthful Trainee Act. It is a statute which allows young people under the age of 26 to have criminal charges set aside. One of the issues is who you're hanging around with. You were the wrong people at the wrong place at the wrong time. And you could save yourself a lot of aggravation if you avoided people like that. I get the sense that you told him that very thing.
Oh, yeah.
All right.
He's been on home detention since this has happened. He's not allowed to go anywhere.
How far did you go in school?
I have 1 semester left.
All right, that's one of the things we're gonna do as part of this probation. You're gonna get a diploma or a GED. I call it dragging people over the finish line. Are you in school right now?
Yes, Your Honor.
Very good, very good. I'm gonna do 12-month probation, which means you could be discharged at the end of 6. There's a $75 fine, $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, and a $480 probation oversight fee. We could cut that in half. Get diploma. No drugs, no alcohol, including marijuana. If we gave you a test right now, would it be positive for marijuana?
Yes, Your Honor.
All right, you're not old enough to smoke marijuana. The people that know about these things determine that marijuana affects your brain development, which it does profoundly. We have a generation of people that started smoking weed when they were 16 or younger. I went to school with lots of them. But now the marijuana is much more potent. It's like drinking 3-2 beer or drinking grain alcohol. It's way stronger and it affects your brain development. So people under 21 aren't allowed to use marijuana, including you. No drugs and no alcohol. The first one will get your levels to 0 and stay that way. Sign a release with Pivotal. So the first term of probation is you're not getting any other trouble. Don't violate any law of any unit of government, the way it's written. No drugs, no alcohol. We'll do a test every once in a while to confirm that. I also want you to get your diploma. The fines are expensive. $350 plus $480, $830. And I expect it's going to be less, $590. If you can stay out of trouble between now and the time you graduate, after you graduate, I'd be willing to discharge you from this probation. And you're on Homes Youthful Trainee probation. All right, you take this downstairs to the probation department.
And my last file is John Schofield. And I would like to make a record on that because my information is spotty.
All right, I thought we had one more guy in custody.
Taylor Young was in custody. That was a dismissal.
Okay.
Ronnie Miller, I believe, is in custody. That's Tim George's file. He's with Pattison right now.
I thought we were there. All right, let's talk about John Schofield.
I'm very concerned with him. I'm doing a hesitant fail to appear. He's not here. I had contact with him in the jail. On the 7th of December, I went to have contact with him at the jail on Sunday, and I was told by jail staff that he had a medical emergency and received a personal recognizance bond to go to a hospital in Grand Rapids. They did not indicate which hospital in Grand Rapids, so I was unable to call and confirm his status. I do not know if he is hospitalized, if he is alive. I do not know what his status is. But I know that he's not in the jail and he is not here.
Somebody, Judge Pattison altered the bond. No, Luke Laurie altered the bond. Per magistrate confirmation with Judge Pattison, bond modified to 2,000 PR.
And there might be a very good medical reason for his failure to appear today. I just don't have enough information to inform the court.
I'll continue this to 12/16 at 8:30. And preliminary examination if needed for 12/23/25 at 1. Need to determine defendant's medical status.
What was that prelim date?
12/23.
Thank you.
It can always be moved. I'm here that day. Judge Pattison isn't, but I don't want to do a bench warrant at this point if he's in a hospital.
Thank you. And I will work to confirm that, but I don't know how successful I'll be. Thank you.
All right, thank you. Ms. Thurman, you enjoyed it so much yesterday. You thought you'd come back here again today? What case are you ladies here on?
I actually wanted to speak to you about that paperwork.
The ticket?
No, it was that landlord.
Oh, yeah, I can't talk to you about it. The other side isn't here. But do you have problems doing it on Monday?
Okay, when you asked me to pick this up so I could review it,
Yeah.
I didn't look at it until I got to work. But this is paid off.
Well, then we'll find out. So go talk to your manager.
I tried to call her and when she answered, I said, "Hey Judy, how you doing? This is after I first want to say that
Her husband died.
And she just started snapping.
Well, I can't talk to you about the case. The other side isn't here. You can't just show up and then I can't have an ex parte discussion with you about a pending case. The attorney on that case, you can talk to him and call him. So if you go out to the counter, they'll give you his name and number. And you can call him and say, hey, this is paid. And you can tell him how you thought you were treated by the manager. But otherwise, if the case is resolved, I'm fine with that. But if not, we're going to address it on Monday. But if it's all paid, then that's all going to get taken care of. All right. If you go out there, they'll give you his phone number and you can call him and talk to him. I don't know what happened with any of the pre-trials. There are about 6 of them. I thought maybe something would be resolved. So Josh, it appears the only we have left is Ronnie Lee Miller. Is there a plea offer in that?
There is. Stop.
You're here on the PPO case? All right, we're a little behind. All right, you're fine. So Shanta Adams is also present.
I'm pretty sure I've seen a lot. I haven't seen it, but I'll go confirm.
And would you check on Mr. George's status? Hi, Judge Middleton again. I left that conference room open for Ronnie Lee Miller. I think he's our last customer of the morning. Yep. All right, thank you. Bye.
Yes. This Adams is here. For your area. As far as Judge Oda goes, he's currently at the bench. I asked the broker has no idea how much he's got left, so without interrupting what they got going on.
All right.
I was just gonna tell him he's still doing a sentencing over there. So.
Yeah.
All right, well, we'll try to finish that before we take up our next matter. We're not as far behind as I thought we would be, but I've just ordered up Ronnie Miller. Laura, I can't find my note on that Adams case. My memorandum.
For me here. No.
Paul, have you got anything left for me?
I don't think so.
I didn't think so either. All right, waiting for Ronnie Lee Miller and Timothy George. Yeah, thanks. Good morning, Mr. Miller. We'll be with you in a minute. We're waiting for your lawyer who is next door in Judge Patterson's court. So don't go away. I'm going to put you just in the waiting room, but as soon as your lawyer gets here, we'll address this.
The court has had an opportunity to review the videos submitted by the defendant. there anything that plaintiff wants to say regarding those?
We know nothing about the person being there. We don't recognize the person or the car.
And Ms. Lyman, how are you so sure that it was Miss Anderson there?
The guy, he was there before by himself taking pictures inside of the basement. And then
He was what?
there before taking pictures inside of the basement. And then this time,
What do you mean so I recall the issue regarding the basement. You're saying this guy entered the home.
no, he didn't come in. That's who was taking pictures outside in the window. Like through the basement window.
That you had talked about before.
And then I seen her, that's why the hand was up when the car had came back past.
So your testimony is you saw Miss Anderson in the vehicle.
Yes.
On what would have been the third video that the court received.
It was the guy coming back around from the back of the house after he seen the camera.
Well, no, I think I may have received them in a different order. But the last one I had was actually, it looked like the back of the premises and there was a deck.
Yeah.
The deck I'm seeing, is that the deck that's attached to the premises you rent?
Yes.
Okay. And Ms. Anderson, you're indicating that you know nothing about that individual. Ms. Lyman, you're sure that that's the individual that was taking pictures inside the premises?
Yes. They never came inside. They were just taking a picture from outside in the basement.
Right, right. What were you going to say, Ms. Anderson? I want to give everybody an opportunity to say what they're going to say.
I never sent anybody to take pictures of the basement. And you said that you let somebody in to take pictures of the basement. I never sent
No,
anybody.
she didn't let someone in. He stood outside and took pictures.
I didn't send it.
Anything else additional from either side before the call rolls?
Not from plaintiff.
Anything else, Ms. Lyman, you want to tell the court?
No, I'm just trying to make sure that the only thing that I have left to pay is the last 3 months, which is the 9,900. Correct.
Well, okay. I'm gonna do it this way. Anything else you want to say? And I'll let you know what you have to pay.
No, not really. I just don't think I should be responsible for court costs, just because when we started coming in, the rent was already paid. And yeah, about the water bill, I don't really feel like I should be responsible. Just she took it out my name, paid it herself. But if I have to, I will. Just the company.
What I'm going to do is I'm going to render my decision, and I'm going to do it this way. The original case that was filed, which is, and let me just get it. It's 25-1C-2176. And that's the one that I'm going to render the decision on. 176. All right. And the court has throughout this entire thing, first of all, reviewed all of the documents presented by the parties in detail. And frankly, am unsure, except as to really what is animosity between these parties as to why there is so much stuff here. And from the perspective of the plaintiff, I would just indicate that the many of the allegations made by the plaintiff regarding her need to get into the premises, certain things that need to be looked at, and all of those things, quite honestly, the court views as just some pretext to interfere with the possession by Ms. Lyman. There wasn't a need. We went through, and just by way of example, we went through a whole seemed a series of hearings regarding the looking at something in the basement of something that potentially could occur that she wanted to get in the house. But Ms. Anderson was really letting her true motivations be known, because every time she would indicate that she needs to look in to make sure that the premises are in some way damaged. And there was no indication whatsoever that Ms. Lyman had done that. She was then at another previous point accusing Ms. Lyman of not being the actual tenant, going so much to the extreme of asking the court to tell her to turn on the camera because that wasn't the person that she rented from and that she was dealing with somebody else. Every hearing, the person that's been appearing has been Ms. Lyman, this Ms. Lyman that I see here today. No one else has appeared. It also seems a bit disingenuous for the plaintiff to say that, because there would have been in-person contact prior to the rental in which she rented to Ms. Lyman and the like. Ms. Lyman may have had people there. She may have had other things, but Ms. Lyman has been the one here and been the one taking responsibility for that. So I don't think that Ms. Anderson, frankly, I'll just be blunt about it. I think she wants to have control of everything, including Ms. Lyman, what Ms. Lyman's doing, who Ms. Lyman has there, and the like. And none of it makes much sense to me. If she wanted to inspect for damages mid-lease, then inspect for damages mid-lease. But she came in here accusing Ms. Lyman of fraud. That has not been substantiated in any way whatsoever, that Ms. Lyman was somehow fraudulently renting the premises. It was just said that that was it, and that it wasn't Ms. Lyman. And, you know, in just over and over doing that. And I don't know why Ms. Anderson wanted to do what she was doing, but it just throughout the course of these proceedings and hearing after hearing, just this sort of berating of the tenant, saying that she wasn't doing something, just continued. While I've heard what Ms. Lyman has said and said through counsel about not knowing that person in that vehicle, I am having a very difficult time believing that to be the case, because there were people coming, testified by Ms. Lyman before, that there were people coming to the premises, all coinciding with Ms. Anderson wanting to get in. Frankly, if this were just a simple issue, and it should be, and that's how the court's going to view this case, it's a simple issue. This is a non-payment case. That's all that it is. There has been no proof whatsoever presented to the court that Ms. Lyman has damaged the premises, is causing any waste or destruction of those premises, or is in any way abusing the premises or violating any terms and conditions of her lease. But what I do think is that she's been harassed by Miss Anderson. And while it may not seem much, when the water bill was coming out, and that kind of popped into this case at some point, she was even in court berating the defendant about paying the water bill. Now, certainly the water bill should be paid, and there are just different ways that landlords go about doing that. But she just continued to go after Miss Anderson about paying the water bill. Kept saying the water bill was somewhere around $1,800. The only bill that I've received today is for $1,315.83. She claims that there are these other payments. I don't know that to be the case. But that's all I have in terms of the water bill is the $1,315.83. I then have, in terms of rent not paid, and I think it was explained to Ms. Lyman that the rental period starting on the 5th, but her lease doesn't end till the 4th day of the end of the term, is that 30-day or month period. So it's not like she's being shorted. She's not entitled to any type of credit for that. But as it regards the rent on the premises, there's a total amount of $19,800 owing in rent. So when I take that and the water bill together, which the water was supposed to be paid by Miss Lyman, I come up with a total amount of $21,115 that is owed by Miss Lyman. Now, I've not made any deductions for what's been paid in at this point. That would be the aggregate amount due. I am concerned that there are then these additional late fees added on. And late fees should not have been charged for the defendant. Whether she paid it to the court late, there are remedies for a landlord. And let me just put it this way. That's part of the problem, is that Miss Anderson tries to make her own rules. And she was paying escrow to the court and should not have been charged late fees. Miss Anderson's justification, as she blurted out, as she typically does, was that she paid the rent late to the court, so therefore she's entitled to a late fee. Not the way it works. The landlord has certain remedies if she were late paid to the court, which, quite frankly, Miss Anderson has been able to take advantage of with the whole start of the trial in this proceeding by an immediate trial. It doesn't give you a right to a money judgment, but gives you a right to an immediate trial. There are those things, but the late fee, not going to do it. So claiming some $900 in late fees, I'm going to take off because that's what's been paid into escrow. So $300 comes off of that. So of late fees, there is only $600 for late fees instead of the $9 that's claimed. Now, the other problem that I have is that I don't know where Ms. Lyman's security deposit is. I can't get a straight answer. What I know is it apparently is commingled with the funds of the plaintiff. It's absolutely inappropriate under our statutes and should be held in a separate account for which Ms. Lyman, because it was really her money that the landlord is holding, has to be notified as to where it is, the financial institution and the like. That is a clear violation of the law in the way that Ms. Anderson is conducting her business. I also don't know that her counting is all correct, because there were certain numbers that had to come off and come on, and somehow the notice that was sent on this case would have been incorrect. The notice that was sent to the tenant regarding the amount she owed would have been incorrect, because there was at least the $100 credit, and then presumably other credits that went to the tenant. Credits of, and I say it this way because it's money that she's paid. It doesn't necessarily change the bottom line, but it's certainly money that she's paid. And Ms. Anderson knew or should know that she's received the funds from Ms. Lyman. But somehow or another, Ms. Lyman has to get herself here to explain to the court that I made these payments. There isn't a ledger, in the sense of a ledger of her payments each month, because apparently Ms. Anderson believes she didn't have to keep a ledger, an account ledger, until the time that she filed the notice, or until, actually what she said is until she paid into escrow. I don't even know where that comes from. That doesn't even make any sense. And certainly it's not a sound business practice by any stretch of the imagination. So what I have is, I have, with late fees, rent, and water, I have the tenant owing $21,715. She has posted, and counsel, remind me, what were your costs that you were claiming?
Costs are $183.59.
Okay. And while Ms. Lyman doesn't believe that she didn't have the cost because rent was paid, I don't find that necessarily to be the case. I think the case, the original case, could have been filed. But it just wasn't. I mean, it could have been filed. It was filed. I'm not even clear when I look at everything that it needed to be filed. As it seems to me that for the most part, Ms. Lyman finds a way to get herself ultimately paid in full. And I'm gonna say this way. I think Ms. Anderson was trying to harass Ms. Lyman. I've said it in the regard to how she handled her tenancy. But I also think, and this was not certainly counsel's doing, but there's a case that was pending before the court that the court was coming back to render a decision on. And for some inexplicable reason, Ms. Anderson files a new case that then gets served on Ms. Lyman as, frankly, as the court interprets it, is just an added attempt to try to pressure Ms. Lyman to pay. the court never got a straight answer as to why this was even filed. But I just find it odd because also, and falsely, at least based upon what's been claimed here, in that complaint, she alleged $1,500 water bill, which supposedly was due October 6th. Now, I've never seen a rounded off water bill. I'm sure it exists someplace, but I've never seen one like that. And that's what she put on there. And again, I think it was just an attempt to try to pressure Ms. Lyman into doing something that maybe she was entitled to. But again, I could never get a straight answer as to why this next case was even filed. It made no sense to me whatsoever. This action was already pending, and again, it just made no sense whatsoever from the court standpoint that it was filed. Because of all of the harassment, I think intentional interference with Miss Lyman's quiet and peaceful enjoyment of the premises, what the court is going to do is the court is going to award on her counterclaim on that $1,700 to her. That would bring the plaintiff's judgment to a total amount of $20,015 plus the $183.59. And counsel, I just want to make sure which case are you getting your costs from? Because is that the new filing or the old filing fee?
We became involved in this case. I mean, in his proceedings after the second case was filed.
Correct. So that I just want to make sure those are the costs you're giving me is from the second.
Well, no, actually, her figure as the costs come from the first case. Is that right?
I was combining.
She was combining them.
Pardon?
She was combining the two cases.
It was the first case. I don't know.
Oh, you don't know. Well, we'll just take the filing fee and the service fee and filing fee was what, $7,575?
No, well, here's the problem. On the first case, I have a filing fee of $130 and a $55 filing fee on the second case.
Okay.
I have a service fee on the first case of $32.30, as well as $32.30 and $32.20, respectively, between the cases.
$32.30, $32.30 and $32.20.
So, yeah, so here's what I'm gonna do. The only cost I'm gonna award, counsel, is I'm just going to award the lower of them. And so I'm just going to award $87.20 in cost.
Okay.
Because and again, it's on a case that should have never been filed, but that's the way I'm gonna do that. And that would make the total judgment to the plaintiff. If they have me do math here, but 0, 1. I get $20,102.20 is the total judgment amount. And this is where I am. $20,120.
Okay, $20.
Or 20,102.20.
All right, okay.
And then Ms. Lyman has posted into escrow, subtract off of this. $8,870.
May I ask, has the court determined that that is the correct figure? Because it was 66 when I came in this morning.
There were 66 and then there was another. I had determined that there was.
Okay.
2,000. Yeah, posted.
Okay.
Ms. Lyman, you have your hand raised.
Yeah, because that doesn't seem right to me. If I only owe, the last 3 months, that's 9,900. With the water bill, that should only be $11,000. And then
11,000. Correct. You know what? I know part of what. So here's what I did. I'm only going to. So the total figure that I came through with rent, water, and late, that we just went through, is $21,015. Okay. I'm awarding them cost of, let's say,
8720.
8720. Would then bring the total amount of their judgment amount up to $21,802.20.
so even in the prior proceeding, when she said she wasn't counting with,
I only gave late fees for 4 of those months.
even though that she had said before.
I understand what she said, but under the lease, she's entitled to.
Even if she said it, or even if it's on recording that she said it.
So how many times do you think you're going to answer the question and get a different answer from me? Well, I think I'm pretty clear in what I said. And then I'm going to subtract out from that figure the $8,870.
Which gives you 12,920,
12,920.
32.
All right. So after the escrow is released to the plaintiff, that would lead to a judgment of $12,932.20.
Even though half of those months I've been harassed.
I gave, you need to listen to everything I said. I gave you a credit of the total amount of $1,700. That is for the harassment that you received. Really what is interference with your possessory interest to the extent it was interfered with. I gave a $1,700, which I will tell you historically is a large amount for that type of claim from this court. But I think that.
Does that need to come off of that?
No, I already took it out here. Okay. So I gave you credit against that amount because this number would be a lot higher otherwise. It is nowhere near the figure that we started out with of the 22, almost 22 and a half that would have been owed, which would have then gotten us somewhere in some bizarre like neighborhood. All right. But basically, if you look at it, Ms. Lyman, effectively, it's going to be the cost, the water bill, and the 3 months of rent plus what's owed on September rent. that's gonna comprise that amount.
All right, we will prepare.
All right, so it's, the total amount is $12,932.20. Ma'am, I know that you were looking at getting everything paid by the end of the month. How long is it gonna take you to come up with that? But you were looking at the 90.
I was looking at the
99, basically 10.
Okay, so I have to pay the water bill in whole instead of paying it in small increments like I was gonna do with the water company?
Yes. That was also part of the calculation that went in with the 17.
Right, but I'm saying.
Because I think she interfered with your ability to have a payment plan for the water.
So I can't do, the water bill in a payment.
Excuse me?
No, I'm saying I can't do the water bill in a payment plan.
She paid the water bill. You're supposed to pay that water bill as it becomes due. I understand what you were trying to do. Again, in the 1,700, that went into my calculation because and I'm not going to even ask because I don't get a straight answer as to why she did that, took it out of your name and the like. But I've taken all of that into account. And so now I'm asking you, because I also understand that if the water bill were out of the mix, you would basically have around a little over 10,000 that would be due. So let me ask you this. Because you got about 13,000 that you got to pay. How are you going to get that paid? Because you're going to be coming up on January rent also, but this isn't included in this. Let me just ask you this. How much time are you going to need to get this paid?
A little after June.
Pardon?
A little after June.
Like, what does that mean?
Last week of January, February.
I can't give you that long because you're going to have January rent come in. You follow me? I mean, you're going to have that next 3,300 clicking in, which is going to kick this figure out. And Ms. Lyman, so that you also understand sort of the time frame that I'm working on. So you got that coming up, but also today's what, the 9th. So the normal rent date in this case would be the 19th to pay it. But I heard what you said to me about when you were going to get the rest of that. There you go. Here's what I'm going to do. All right. Listening to what you said, the order of eviction date on this matter will be January 5th, 2026. So that amount would need to be paid by that date. Now, so that, and I'm going to say this directly to you, Ms. Anderson, the monies that come in must be applied to the judgment. So if she paid $3,300 and the judgment is still outstanding, apply to the judgment. You can't just say, I've taken it as January and she still owes me this. It may be that if she gets that money all by that amount paid and it hasn't paid January rent at that moment, you're going to have to start over on another case. Am I clear on that? Am I clear on it? This is just simple math. Any monies that come in must be applied to the judgment. Don't come back in here having accepted 3,300 saying you're applying it elsewhere.
We understand that, Your Honor.
Thank you. I'll let your attorney explain that to you.
There's one point at the conclusion of this case. What is it that?
The 2 pen drives.
Yeah, she said the court has 2 pin drives that she'd like back.
you know what? She's been bugging me about those things specifically direct to the court a motion of what you would like returned. And I will look at it, but nothing is going to be returned until the appeal period expires.
I have one other question. Do we prepare the judgment or does the court prepare the judgment?
I'll let you do it. All right, thank you. I'll talk to him. Thank you. You, and Ms. Lyman, make sure you get a copy. At some point, they'll prepare the judgment. I'll sign off on it. Make sure you have a copy of it. Come up to the court, get a copy. Okay? All right, thank you. So, is everybody here on the explanation?
Yes, sir.
Okay, everybody's here? Okay, you guys have to give me a couple minutes. Otherwise, I'd find somebody to yell at. It'd probably be him, right? All right, Kurt's gonna stand in. No, I'd take her too. Kurt's gonna stand in. All right.